Initial pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Welcome everyone to the March 3rd meeting of the Ramsey Planning Board. The New Jersey Open Public Meetings Law was enacted to ensure the right of all citizens to have advance notice of and to attend all meetings of public bodies at which any business affecting the public is discussed or acted upon. In accordance with the provisions of this act, notice of the regular and special scheduled meetings of the Planning Board were published in the legal ad sections of the Bergen Record and the Ridgewood News on October 31st, 2025. Before we do our roll call, we have a couple of members to swear in. Mr. Zavala will be sworn in, and Ms. Daniel is going to be sworn in, who is going to take over the unexpired term of Mr. Carey, who has resigned from the board.
Okay, Mr. Zavala, this is you being sworn in for your second term on the board. If you both raise your right hand, and repeat after me. I, repeat your name,
I, Daniel Zavala,
do solemnly swear that I will faithfully, impartially, and justly perform all the duties of the office of Planning Board Class 4 member, according to the best of my ability. I do further solemnly swear that I will support the Constitution of the State of New Jersey,
and
that I will bear true faith and allegiance to the same. True faith and allegiance. And to the governments established in the United States and in this state. Under the authority of the people. So help me God. Congratulations.
Okay, Ms. Lupo, can we have the roll call, please?
Yes, Councilman McKeeson? Here. Ms. Daly? Here. Mr. Barback?
Here.
Mr. Cornbo?
Here.
Mr. Strollo? Absent. Mr. Bedoni?
Here.
Mr. Zavala?
Here.
Mayor Dillon? Absent. Chairman Iorga?
Here. We have our minutes of our January 6th meeting. Do I have any additions or deletions to those minutes? Not hearing anything. Can I get a motion to approve the minutes, please?
Motion to approve.
Thank you. And a second?
Second.
Thank you. Roll call, please.
Yes, Councilman McKeeson?
Yes.
Ms. Daly? Yes. Mr. Barback?
Yes.
Mr. Cornbo?
Yes.
Mr. Bedoni?
Yes.
And Chairman Iorga?
Yes. We have 4 site plans waivers this evening. What we'll do is we'll call you up one at a time. You can have a seat at the table. Give your name and address for the record. Describe your application, and then the board will ask any questions that we have on the applications, and we'll act on all of them at the end. So we'll go through all 4, and then we'll act on them all together. So the first one this evening is Michael Evangel, DC. Good evening.
Hi. Michael Evangel, 145 North Central and North Franklin Turnpike in Ramsey, Suite 309, a big office, and it's a chiropractic office. I've been licensed for 40 years in the state of New Jersey, and I was in Ramsey from 2008 to 2020 previously. I was in Paramus, then come back to Ramsey.
Okay, and it says it's going to be one employee, so basically it's just you?
Right, chiropractic office, health practitioner.
Okay. Any questions from any members of the board?
Dr. Evangel, I think I already know the answer to this, but you will not have any drugs or anything administered there, just
Supplements.
supplements?
Right.
But no,
No, but that's illegal for the chiropractors to do.
Thank you very much. Thank you. Thank you, Mr. Chair.
Yep. Any other questions?
The state of Washington can deliver babies at one time.
Not hearing it? Okay, so you all set. We'll act on this in a second, and welcome back to Ramsey. The next one we have this evening is Rebel Core Management. Good evening.
Hello, good evening. My name is Stephanie Giancarelli with Rebel Core Management. The address is 1000 Lake Street, 700C in Ramsey. We are proposing a modern Pilates studio for the use.
Okay, it says here 2 full-time employees, so
Yes.
yourself and one other?
It would be myself and our business partner, yes.
Okay. hours, basically, it's, I guess, by appointment, sort of, when you get the classes?
Yes, there's class times. I didn't want to inundate you with a bunch of stuff, but yes, we have class times beginning at 5:30 a.m. through 7:30 p.m. with gaps in the middle of the day.
Okay. Any questions from any members of the board?
Is this your first practice, or were you someplace else before here?
I'm sorry.
Is this your first practice, or were you someplace before you came to Ramsey?
So we have two other locations in Essex County and Morris County. This would be our third.
Great. Thank you.
Thank you.
Okay, any other questions? No? Okay, you're all set. Welcome to Ramsey.
Thank you. Thank you so much. Have a good night.
You too. Okay, next we have, Erica Smuckler. Good evening.
Hi, good evening. I'm Erica Smuckler. I'm a Courageous Kids Counseling as a child and teen counseling practice. And the address is 300 Lake Street, Suite 4 in Ramsey.
Okay, and I assume it's by appointment, right?
Correct.
And you're gonna be the sole, employee there?
I'll probably have about two practitioners.
Okay, all right, so would they be full-time or part-time?
Part-time.
Okay, so why don't we just update that on the waiver? We always ask this question because you're dealing with children. What is your procedure for drop-off and pick-up? I assume the parents always have to be with the child?
Yeah, there's a waiting area for the parents.
Okay, so the parents will bring the child in, and then if the child is having the session, the child will go back to the parent and leave with the parent, right?
Right.
Okay. Any other questions for any board members? No? Okay, you're all set. Welcome to Ramsey.
Thank you.
The last one this evening is MJB Home Entertainment.
Hey, my name is Martin Benson, and the location, well, the company does photography and video, and it's 623 Swan Street in Ramsey.
Okay, when you say video and photography, you go out and you shoot weddings, things like that?
So occasionally we do go to locations to shoot. Like tomorrow we're going to Philadelphia to take pictures in an office, but people come to the studio to do headshots primarily.
Okay. And you'll have yourself, I assume, and you said 3 part-time employees?
Yeah, like a makeup artist, and different people will come depending on what's needed.
Okay. Any questions for any members of the board?
I do, going back to the question about children and headshots and things for modeling or whatever, do you have parents there at all times? And talk about that and how that works?
Yeah, we don't too often do kid stuff, but yeah, if any kids are there, the parents come. There's like a waiting room, and so the parent could be in the room during the shoot or sitting in the waiting room, but it's just like the kids stuff is usually for acting, like actors need headshots when they're getting started. So.
Thank you.
Any other questions? No? Okay, you're all set. Welcome to Ramsey. Okay, do we want to act on these waivers this evening?
Yes, Mr. Chairman, I make a motion we approve the site plan waivers as presented.
Thank you. Could I get a second, please?
Vice Chairman, second.
Thank you. Roll call, please.
Yes. Councilwoman Keeson?
Yes.
Ms. Daly?
Yes.
Mr. Varga?
Yes.
Mr. Palumbo?
Yes.
Mr. Verdoni?
Yes.
Mr. Zavala?
Yes.
Chairman Irish?
Yes. Okay, we're going to open up the meeting now to public comment. For public comment, this would be on anything other than this evening's public hearing, which you'll be able to comment on as I'll discuss in a second. Anyone wishing to address the board should, when recognized, step up to the microphone and give his or her name, spelling the last name and address. Please speak in an audible tone for the record and address your comments to the chair. There will be a 5-minute time limit per speaker unless reduced because of the volume of business on the agenda. No time shall be ceded to anyone else, and no time shall be saved for later use. Unless otherwise directed by the chair, any responses may be given during the board's comments, which immediately follow public comment. No one other than the person having the floor will be permitted to enter into any discussion without recognition by the chair. Does any member of the public have any comments this evening on anything other than tonight's public hearing? Okay, second call from any public comments. Third and final call. Okay, not hearing any, we'll close public comment. Any comments from any members of the board this evening on anything other than tonight's public hearing?
Yes, Mr. Chair.
Yep.
To my borough friends and colleagues, I am grateful for your support during the loss of my father, Henry Cusick. Your calls and messages and thoughtfulness are incredibly comforting. Thank you very much, guys. I appreciate you.
Thank you. Okay, anyone else this evening? No? Okay, so tonight we have the public hearing on the 2026 amending housing element and fair share plan. Just so we have a lot of members of the public here this evening. We have with us Mr. Burgess, who will be giving the presentation. What we are going to do, because I want to make sure that everyone has an opportunity to ask any questions or comments and be mindful of anybody's time constraints. After Mr. Burgess is done with his presentation, we'll open it up to any questions or comments from the public. Initially, everyone will have 3 to 4 minutes to ask what they want. Once everyone has had an opportunity to speak, you certainly can come up again. But I want to give everyone the opportunity, so if there's time constraints that anyone has, they have an opportunity to speak before someone speaks for a second time. Okay, with that, so we will now open up the public hearing on the 2026 amended housing element and fair share.
Mr. Chairman, I have a couple of procedural questions before Mr. Burgess starts speaking.
Okay.
Okay.
Name and address for the record, please.
Sure. My name is Joe Carey, 498 Island Road, Ramsey. First of all, no public meeting notice was read, I suppose that was stated. You did not read it at the top of the meeting. Now, the one thing I wanted to call attention to was
what did I not read?
On the agenda, there's an open public meetings law notice that should be read out loud.
And I did read it.
I apologize then. I apologize. I didn't hear it then. I'm sorry. Members of the public have not had a reasonable opportunity to review application materials in advance. The Fair Share Housing Element Plan and related mediation agreements, totaling 213 pages, were not available to us until 4:30 last Wednesday, February 25th, less than 6 days ago. Normally, items being heard would be available on a board's or council's agenda page, where members of the public would normally expect to find such document. Instead, we were told on Wednesday it was on the planning board page. Can I ask the board to address this issue before testimony proceeds? And on another point, we members of the public were only aware of this R5E Island Road overlay directly impacting our properties when we discovered it on the February 11th Mayor and Council agenda less than 3 weeks ago. Now we don't have representation tonight. Page 15 of the statement of reasons in the mediation agreement that I would guess all board members have. It's Appendix 1 of the House.
How is this procedural?
We haven't had time.
But you're going into.
We don't have, so we ask your forbearance in the fact that we don't have legal representation. Okay, so
okay.
Thank you. Okay, so I have a question for the chair. Am I correct that all members of the board have the full amended plan?
Well, you mean Mr. Burgess's
Correct.
plan? Yes.
Yes.
They all have.
And they have all the exhibits and appendixes, so if someone asks questions, they'll be able to refer to those plans. Okay. And on the agenda tonight, there is the amended housing element and fair share plan, and there are 3 ordinances. Will the plan and each of these 3 ordinances be acted on and voted on separately?
Yes.
Yes, they will. So I guess this would be a Mr. Whitaker question. Can you please explain to the members of the public what the role of the planning board in relation to the master plan and what is being heard tonight?
Absolutely. That's what I was going to do just before you got up.
Thank you. Thank you.
Okay, so I will go over it.
Okay. And then second question to Mr. Whitaker. Can you please tell the members of the public what the law says about the relationship of the various elements of master plan and if they have to be consistent with each other as part of your comments?
That's going to be part of the overview and explanation given by our plan.
Thank you, sir. And also, can you inform members of the board, as well as members of the public, under municipal land use law, what are the procedural differences between the votes on the amended plan
and the ordinances?
The answer is yes, and I will.
Okay, thank you. And another one, under the municipal land use law, when a zoning ordinance is sent to the planning board for recommendation and then is sent back to the governing body as not recommended, does the governing body have the option to disregard the non-recommendation by the planning board and adopt a zoning ordinance anyway?
The short answer to that is yes, but they have to have a supermajority.
Okay, thank you, sir.
Okay. I guess, Mr. Burgess?
Oh,
Go ahead.
I'm just going to address it. I was planning on doing this anyway. Mr. Terry asked the question, so I'll go through it. Tonight, the planning board has before it an amended housing element fair share plan, as well as 3 ordinances. Mr. Burgess is going, as a licensed planner, is going to testify this evening to explain first the requirements of each municipality in the state of New Jersey and what they must adhere to under the amendments to the Fair Share Housing Act, which is legislation that was promulgated by and adopted by the New Jersey Senate and the New Jersey Assembly, and it was signed into law by Governor Murphy. The planning board under the municipal land use law has the exclusive jurisdiction to adopt the master plan. The municipal land use law is a state law. The housing plan element is part of the master plan and is required in accordance with the legislation and requires the housing element and the fair share plan to be reviewed. The planning board, as I already said, has exclusive jurisdiction to review that. And the planning board, when they do this review, has at the end of the review, must either adopt it or not adopt it, but that is within the planning board's jurisdiction. It's not something that goes back to the governing body. The public hearing tonight will be conducted like any other public hearing. Mr. Burgess is going to testify, and after he testifies, then as Chairman has already stated, members of the public will have the ability to ask questions and provide public comment. All testimony will be under oath. The board will then make a decision regarding the plan. As indicated in Mr. Burgess' report, the plan is a result of a settlement pertaining to the objections raised to the borough's 4th round obligation under the municipal land use law and under the fair share requirements. With that said, after the master plan has been considered by the board, the next step will be the ordinances. And as Mr. Carey asked, and I confirmed, each of the ordinances will be reviewed separately. The ordinances at this point, under the municipal land use law, the mayor and council have introduced these ordinances. Under NJSA 40:55D-26A, after it's introduced, an ordinance is sent having to do with land use aspect is sent to a planning board. The planning board has 45 days within which to make comments back to the governing body as to whether these ordinances fall within the consistency of the master plan. The planning board does not adopt an ordinance. They just make a report back to the mayor and council. And then the mayor and council has this on their agenda to either adopt or not adopt the ordinance at their meeting. So I just want that understood, that it's not the planning board that adopts ordinances, it's the mayor and council that adopts ordinances. But there is a requirement in the municipal land use law that a planning board has the right to review the ordinances and then make a recommendation back to the governing body. And as I stated, each of those ordinances will be reviewed and will be acted upon separately. So at the end of the evening, in essence, there would be 4 votes. The master plan first, and then after that, a separate vote in connection with each of the ordinances that will be explained. That's the overview of how this procedure works. It's a procedure that is required under the state law known as the municipal land use law. Are there any questions of me as to how we're going to proceed? Okay, then I turn it over to the chairman.
Thank you. Mr. Burgess?
Yes. I think Bruce wants to swear me in first.
Yes. If you would raise your right hand, do you swear or affirm the testimony you're about to give will be the truth and nothing but the truth?
I do.
Please proceed.
All right.
Qualify the witness?
I can qualify myself.
The witness has to qualify himself first.
Okay. I appreciate that, Joe. Um, Quick background on my planning experience and my affordable housing experience. I'm licensed as a professional planner in the state of New Jersey. I've been licensed since 1981. I'm also a member of the American Institute of Certified Planners and a member of the American Planning Association. I have, up until recently, sat on Rutgers University's Blaustein School of Planning and Policy Development as a associate member, overseeing a lot of different things for that program. I'm also a former member of the state planning entity that oversees all the licensing of planners in the state of New Jersey. I've been a guest speaker down at the League Municipalities for many, many years. I've also spoken at the national planning conferences for quite some time. Let's put all that aside for a moment and talk about my experience as a planner doing affordable housing. I've been active in that area since the very beginning of this process, which began in 1987 when the Council on Affordable Housing first established their affordable housing need numbers for every municipality and established a series of regulations governing that. At the time, those regulations were about this thick, and everybody was aghast because they thought that was so much. Today, they're about this thick, and we look back upon that first and second round of affordable housing is now the golden age of affordable housing. As a firm, in any given year, my firm represents anywhere from 40 to 50 municipalities. With this fourth round of affordable housing, which began with 2025, we've prepared a total of 43 housing element and fair share plans, which the program has indicated to me was the most of any firm in the state. In addition to that, I am a special adjudicator. It's a term used to indicate that I am assisting the judges who are overseeing this entire process. There are 10 different judges that have overseen what's called the Affordable Housing Dispute Resolution Program. And from now on, I'll just refer to it as the program. I've represented 8 of those 10 judges reviewing housing plans that have been submitted to the program, and I assist the court in determining whether or not those plans have been prepared consistent with the applicable legislation and regulations. With that, I would ask that I be accepted as an expert in this field.
2 questions just for the edification of the public. Mr. Burgess, as a licensed planner in the state of New Jersey, is it not one of the requirements that you have a full understanding of the municipal land use law?
That is correct, yes.
And a full understanding of the case law that interprets the municipal land use law?
Yes.
And a full understanding of all of the requirements and conditions that are set forth under the fair share housing rules, I'll call it, that have been propagated not even in the last round, but this 4th round?
Correct, yes.
And you have been a planner for the Borough of Ramsey for how many years?
About 15.
And so you have a full familiarity of the Ramsey Planning Board ordinances,
yes,
and the municipality itself?
Yes.
And in fact, you have promulgated, and the board has passed, the governing body has passed other zoning ordinances in the past pertaining to Ramsey?
Yes, which my office has prepared.
Are there any questions by any members of the board first, about Mr. Burgess' qualifications? I trust not, because we've used him as our expert for years.
Yeah, and Mr. Burgess, just to also clarify, you've prepared the other elements of the master plan?
I have over the years, yes.
Thank you.
Any questions by members of the public as it pertains to Mr. Burgess' qualifications?
Yes, Joe Carey, 498 Island Road, Carey. Thank you. Actually, most of my questions have been answered. So we note from the January 26th statement of reasons, 700 challenges were filed before August 31st.
700 challenges were filed. It involved 424 municipalities. There were multiple challenges. For example, in Parsippany, we had 28 or 29 separate challenges to that one housing plan. So
And so out of the 43, your 43 clients, I would assume you had more than 43 challenges. You just said 28.
No, what's really interesting is 424 municipalities filed housing plans. We did 43 of them. Of those 424, Fair Share Housing Center objected to even 400 of them, which is interesting in light of the fact that they don't have any licensed professional planner working on their, with them in-house. And they are all lawyers. None of them have ever prepared a housing plan, but they saw fit to find fault with 400 of 424. We have represented some of the larger municipalities in the state, from Parsippany to Cherry Hill down in South Jersey and everywhere in between. But on the other hand, we also represented Teterboro, one of the smallest communities. Fair Share Housing Center did not object to that one.
Of course. So we agree that he's more than qualified. We just wanted to clarify a couple of the questions involving the fourth round. Thank you.
Okay. So
With that, Mr. Burgess can proceed.
let me talk.
Before you start, just for any of the members of the public that are watching this on YouTube, Mr. Burgess does have a presentation. I don't know if you can see it online. If you want to download it or view it online, it's been posted on the borough's website on the first page under Newsflash.
Before we get into the PowerPoint, let me just give a little background on a few things. Because over the past few months, and the fourth round technically began in 2025, and the state legislature gave a very truncated time frame within which municipalities had to prepare housing plans, hear objections from developers in Fair Share Housing Center, respond accordingly, prepare amended plans to address that, and at the same time, work towards mediation and settlement of any of the disputes. And over those past few months, I've been going around the state talking about this issue. And the one constant drumbeat I've heard wherever I go is that why is there this rush to judgment, first of all? And secondly, why was so much of the decision making taking place behind closed doors? And then thirdly, what's with these ridiculously high affordable housing need numbers that the state has given every municipality, particularly municipalities like Ramsey, where you're a fully developed municipality. And I will say, I live like 10 minutes away from here, in the nearby municipality. So I'm very familiar with a lot of municipalities in Bergen County. I've been a long-term resident. And in particular in Bergen County, where we have basically fully developed municipalities, the state has still seen fit to give us very, very high numbers. Fortunately, there is a process to reduce that obligation, and that's one of the things I'm going to get into. But going around the state and taking a lot of heat at these meetings because people assume that I'm an advocate for Fair Share Housing Center, which I am not, but that's the perception when we start talking about this issue. But one thing I found out about Ramsey, which was really rare and not unique, was the fact that, and I actually found it somewhat heartening, is that only here, all the towns that I've been through, was there a significant letter writing campaign which expressed the concerns that you have. So in going through all those letters, I really appreciated the fact that in large measure, these letters expressed concern, not outrage, which is more typical of what I found around the state. There was some outrage, but for the most part, you simply were identifying, areas of concern and raising thoughtful questions about the process, the numbers, why this site versus that site. And because of that, it helped me refine my PowerPoint to hopefully answer the questions that you were all raising. And I have to say, I found them all very legitimate questions. So I've got a 25-minute PowerPoint presentation to present. Afterwards, I'll be happy to answer your questions, and what I'm hoping is that we can have a thoughtful dialogue about some of the issues that you've raised that I'll bring to the floor in the PowerPoint. And in that way, you'll understand what some of the issues are that planning boards and governing bodies have faced, why the state legislature is the ones that really put municipalities behind the 8 ball, because they're the ones that created all these regulations. It was not a local governing body or a planning board. And given all that and the analysis that you'll hear, you'll find that, unfortunately, in large measure, municipalities have few options to deal with. But even with that, we try to minimize the pain as best we can. And hopefully you'll agree with me when I go through the PowerPoint. So we could start with slide 1. Now this slide, I think, gets right to the heart of the immediate question, because I hear this everywhere I go. Why bother to comply? As I said earlier, not every municipality has decided to participate in the Affordable Housing Dispute Resolution Program. We have 564 towns, 424 are taking active participation. And the reason why I think it's important for municipalities to comply is that if you don't, and you fail to comply with the Mount Laurel Doctrine and the New Jersey Fair Housing Act, you can have all of your local ordinances be deemed unconstitutional. And I say that because this process started with Mount Laurel 1 by the New Jersey Supreme Court back in 1975. And at that time, they ruled that every developing municipality in the state, I think we can move to the next slide already. Every developing municipality in the state has a constitutional obligation to provide for its fair share of affordable housing. And what was interesting about that decision, it ran for, I think, 268 pages, and immediately every lawyer and planner focused on basically one paragraph that talked about every developing municipality has an obligation. And everybody was immediately trying to point to another municipality in their region that, statistically speaking, has a greater level of development, and compared to that municipality, we're not developing, they are. And so they have the obligation, we have none. And that went on for about 8 years. And in 1983, the Supreme Court revisited the issue and said, the heck with what we said back in 1975. We're going to say every municipality has this constitutional obligation. But they did then point to what was then the state plan, which broke up the state into growth areas and non-growth areas. And they said every town in the growth area, which is basically all of Bergen County, has a greater obligation than those towns that are identified in that plan as being in a non-growth area. They also urged that the state legislature take this issue, and deal with it, because they didn't feel it's sort of consistently been issues that the court had to deal with. And that's what the state legislature did. They created the New Jersey Council on Affordable Housing, called COA, and they put together numbers in 1985 and 1986, published in 87, and that became what was called the first round of affordable housing obligation. And we'll get into what that obligation for Ramsey was in a moment. There were subsequent rounds, initially every 6 years. Later on, it became every 10 years. We are now in the 4th round of our obligation. So when the Supreme Court talked about the Mount Laurel Doctrine, that's the issue when I was talking about the constitutional obligation. That was the Mount Laurel Doctrine. And keep that in mind when we go farther into this analysis. A second question that I often get at these meetings is we hear about a builder's remedy. And what does that mean? A builder's remedy, and that's the next slide. A builder's remedy is a court awarded site-specific relief given to a developer who has sued a municipality. And if they are able to show that the municipality's housing plan is deficient, doesn't properly address the town's affordable housing obligation, or they haven't even prepared a housing plan, because that sometimes is the case. Also, the municipality is determined to have failed to address its constitutional obligation, and they then have a significant problem on their hand, because that developer then can decide for himself or herself how many units and what size building and how it will fit on a piece of property, and the court will give that person the right to build accordingly. The poster child for that process is right here in Bergen County. I'm sure many of you may have read over the years about what happened in Englewood Cliffs. Englewood Cliffs refused to pursue a housing plan that addressed its obligation, and they fought to fight for years. But in the end, when they lost, they not only lost that litigation and had to prepare a housing plan, but the court took away the rights of the planning board and the zoning board to even review development applications in the town. And they appointed what was then called a special master. Now it's called special adjudicator. But they appointed a special master who would review all those plans that were filed with that town for years, until they finally changed their tune and prepared a housing plan. Now, the rationale behind the concept of builder's remedy was very simple. It's what was the hammer that would encourage municipalities to prepare these plans, so they would not have to face that kind of eventuality. Now, the third question that we always get is, well, what's the site selection criteria, which is the next slide, that is used to determine whether a site is appropriate or not for affordable housing. Overwhelmingly, the courts and Fair Share have taken the position that proximity, and I should also say the state plan, takes the position that proximity to mass transit is number one on the list. And secondly, access to the regional highway network is on the list. Those are the two primary driving forces that the courts and Fair Share argue are appropriate locations for higher density development. Beginning with this fourth round, which just began this past year, a new element has been added to the mix. With the fourth round, they say that if you're a vacant land adjustment municipality, such as Ramsey and just about every town in Bergen County, you have an obligation to address what's called unmet need. I'll get into what that means in a minute. But it means that you have to you have to redevelop existing developed properties at a certain percentage to address a portion of that unmet need obligation. Okay, so that's the issue that I think is what drove this municipality to look at Island Road and Franklin Turnpike as overlay zones. Now, additional criteria that is often talked about in the courts and with Fair Share is whether or not your site is in a location that's in a sewer service area. It talks about land use compatibility, because although the developers will try to scare you by saying, if you don't permit us, we're going to come in with a 30-story building. And I've actually seen close to that in one Bergen County municipality, which the judge shot down, but that there's that fear factor. You still have to talk about land use compatibility, but it's balanced with the need to address a portion of your affordable housing obligation. So if you're a municipality, for example, that has a typical 2 or 2.5 story building height, they will say we should allow you to go to 3 stories, sometimes 4 stories, and in some instances even 5 stories to address at least a portion of your affordable housing obligation. So there's that balance that we are always wrestling with as we're preparing housing plans to try to figure out how are we best going to do this balance and still minimize the overall impact on the community. I keep flipping this because I don't want to keep turning my back on everybody to look at that. So, as I said earlier, there are 4 rounds of affordable housing obligation. This slide shows you what those 4 rounds consisted of. There's also something called present or rehabilitation need that runs through the 4th round. And for that, our obligation here is 51 units. Now, the 51 units were derived from the idea that you looked at your housing stock, you looked at income levels, you looked at people that are considered low and moderate income households, and then they do estimates on, percentage-wise, statewide figures of how many of the housing units in a municipality are occupied by low and moderate income households, and such units also are in need of rehabilitation. Our number became 51. To short circuit that whole issue, this municipality, like just about everybody else in Bergen County, is relying on the County Housing Improvement Program for funding to help those residents to participate in the county program to help fund rehabilitation of their homes. It's the prospective need, or the new construction needs, that's usually where the battles begin. The first and second rounds combined covered the years 1987 to 1999. And at that time, our obligation here was 189 units. In the third round, the third round was a total mess. It started off to be 1999 to 2005. Unfortunately, COA decided to change the process that was successful in determining housing need. In the first and second round, they worked through a whole different growth share methodology, and multiple times they published their housing need numbers. People sued. It went to court. The court said you didn't do it right. And it took until 2015 for the courts to finally say, COA, you've become dysfunctional. And that was the term they used in the case. And therefore, we're going to take over the process. The courts are going to take over the process. And by the time new housing need numbers for that third round took place, and now it was a 10-year period, so they stretched it out technically to the third round was from 1999 to 2025. And that's when the numbers jumped dramatically, because now it was a 26-year period. So that number was 736 units for Ramsey. And now with the 4th round, initially, and with the 4th round, again, the whole process has changed. With the 4th round, they created this program that I mentioned earlier. They had the Department of Community Affairs, DCA, generate what they called preliminary numbers for municipalities. For Ramsey, I believe it was 503 or 504 units. And we went to bat to try to reduce that number. We reduced it down to 450. The courts accepted that number. Fair Share gave us a fight about that, but we prevailed and we reduced it somewhat to 450. Now, that's not the end of the game there, because for towns that are fully developed, you are entitled to what's called a vacant land adjustment. And in order to do a vacant land adjustment, what we had to do is look at all the vacant property in the municipality, overlay a whole bunch of environmental constraints, steep slopes, wetlands, wetland buffers, sealand stream corridors, and wherever that fell on top of vacant land, we were able to subtract that acreage from the consideration. But what was left, that vacant acreage that was not environmentally constrained, resulted in what was called a realistic development potential. And the courts have accepted this process. And during the mediation process and the review, Fair Share and the developer, who had also objected, took issue with the way we did that analysis, but in the end we did prevail. So the next slide, that table on the bottom shows you what the original obligation was for the first.
Do you want to go down?
No, we're here. That's good. We were able to address the entirety of our 189 unit obligation back in the first and second round. And I'll show you how we did that in a moment. For the third round, although our number was 736, we calculated the RDP at only 54 units, meaning and the difference is 682. So we really shook out the significant potential impact on the community. In the fourth round, our number was 450. We have an RDP of 26. So the difference is 424. Now, what does that difference mean? If you remember earlier, I talked about the term unmet need. Unmet need is that difference between what your original number was versus your RDP figure. And you are obligated by the legislation to address the entirety of your RDP. You are not obligated to address the entirety of your unmet need, but you are required to see how you can address at least a portion of it. Now, during the third round, or at the end of the third round, our office had done an analysis of a lot of municipalities throughout the state, and we figured out that, on average, towns are addressing about 30% of whatever their unmet need was. In the fourth round, we haven't done that analysis yet because the plans are still being approved. But from our experience with the ones we prepared and the ones I've reviewed as adjudicator and other towns that I've looked at, it appears that towns are typically dealing with about 50% of their unmet need. So let's talk about how we're dealing with all these numbers and that unmet need factor and what that means for you. So very quickly for the first and second round, our obligation was 189. Now, we had a plan that addressed 163 units of that 189. But what's interesting about this, back in the first and second round, you were entitled to do what's called a regional contribution agreement with another willing receiving municipality. So we were able to ship out the equivalency of 94 units of our obligation to Jersey City. And they took that money to rehabilitate housing in their community. So if you shake out that 94 units that we shipped out from the 163, that meant that although our obligation was 189, we only had to build 69 units here in town. And the reason why we did that was because we also got what's called bonus credits for 26 units. Now, those bonus credits are from, at the time, you can get 2-for-1 rental bonus credits. You can get additional bonus credits if you're providing senior housing. There's a few other components to that, but suffice it to say that up to 26. So out of 189 units, we ended up having to build about 36% of our obligation and still get certification of our plans. Now, there was the, let me just skip the page. In the third round, our RDP was for 54 units, and these are the projects. It could be a little difficult to read. These projects included Timber Valley, 2 projects on Decimone Court, one for family sale units and one for family rental units, and some Section 202 senior rental housing. all of those units had already been built, but because of the way we mixed and matched things, we were able to shift all those existing developed units to the third round RDP. So we did not have to build a single additional unit. We got 40 affordable units, credit for that. We got 14 rental and senior bonus credits. And in that way, we dealt with the entirety of our third round RDP without having to build any additional units in town. Now, it still leaves us with the unmet need for the third round. And if you recall, our obligation, our unmet need, not obligation, but the unmet need number was 682. And the table before you shows about 195 units that we put into our plan. But again, we took an additional number of RCAs that we shipped out to Jersey City and applied it here. That was 56 units. And there were 95 units of existing units and other developed projects that you did early on in the first and second round, which we were able to shift here. And in that way, again, without having to see much in the way of new construction, there's only 44 new construction units that we had to deal with in this third round to address 682 units of unmet need. And we were able to get the court to approve that. So that leads us to the fourth round, where our obligation, our RDP number, was for only 26 units. And here we talked about the special needs housing in one project, which has been built. We recently zoned property on northbound 17, 1 Constantine Drive, which is right before the entrance into the Home Depot, for lack of a better term. That property is there. At 425 Island Road, there was a site plan approval for a 70-unit project, which would include 11 affordable units. 5 of those 11 were applying to this 26-unit obligation. And then there's 40 North Franklin Turnpike. We get 2 units of credit, and that was part of our fourth round settlement agreement. Now, I do want to point out there's one typo in the housing plan. In the table 5 on page 4 of the amended plan, the total is 26 units as shown here, but the table on the page shows 24 units. If you add up the numbers, it does say 26, but we will correct that with the final version. And that leads us to probably the properties that you are most interested in. That's the fourth round unmet need. Now we've got 424 units. We are required to address 25% of that obligation through redevelopment, which means 105 units. Now, we have identified how we are addressing that through 2 special needs rental units, an additional 6 units from 425 Island Road that I mentioned earlier. The overlay zone that I think most of you are here about is for 70 units. There's the R5F zone in North Franklin Turnpike for 27 units. And then we have what's called a mandatory set-aside ordinance, which means that, and this is part of our settlement agreement, if anybody were to come in and propose 5 units or more multifamily housing, they would be obligated to do a 20% set aside. Now, what that fourth, let's talk about the R5E Island Road overlay zone first. The difficulty with this area was that Fair Share Housing Center immediately seized on this area as a focal point. And they did that because of the proximity to the train station and because of the proximity to the interchange onto Route 17. They initially were proposing a much, much higher density and a much, much smaller minimum lot size than we wanted. And we fought over the density, and we finally got them in the court to agree to a 19 unit to the acre density. And it could only happen if somebody accumulates to a minimum 2.5 acre site. Now, in that overlay zone, let me first explain what an overlay zone is. It allows for that density as an overlay zone. If it doesn't happen, the underlying current single-family zoning is still in place. So somebody can also build single-family housing there. What we find is that there is only one lot of the 30 lots in this zone. This is actually 2.5 acres in size. There are only 5 lots that are scattered around that are over 1 acre in size, and fully half of the 30 are less than a third of an acre in size. So for the most part, it would take a significant amount of effort for someone to come along and convince you all to sell your property to accumulate 5 or more lots to build. Now, in large measure, that means it's really up to you if you want to save your neighborhood. Because we cannot, at Fair Share Housing Center, nor the courts, can force you to build any affordable housing if you don't want it done. I see people shaking their head no, and I'll ask why when it's your turn to speak. But, that's the bottom line issue about all overlay zones throughout the state of New Jersey. The municipality is not condemning property to make it happen. It's all up to the property owners if they want to sell their properties or not. And I've heard time and again throughout going around the state that there's just a misunderstanding about what overlay zones mean. But it's really in large measure in your hands because nobody can force you to sell and build affordable housing here or higher density housing here. Now the same holds true with the North Front and Turnpike overlay zone. This was also a bone of contention with Fair Share. They initially wanted to extend this zone to the entirety of North Franklin Turnpike all the way down to the Allendale border. The same way, and I forgot to mention, they also wanted to extend Island Road's overlay zoning much farther south than we ended up having it. Here, because the lots are smaller and some are already developed for multifamily housing, we have a density of 13 acres to the acre. Probably the most significant distinction between the two areas. But again, the issue for those that are in that area, the issue is if you do not sell, that housing does not get built and your single family neighborhood remains intact. Now, that's the broad overview of how the municipalities address their obligation. I think in large measure, Ramsey has done a good job in terms of minimizing the overall impact on the community based on all the numbers that I just ran through. So the question then becomes, well, what's the next steps? And that's the last slide. The planning board is obligated to vote on this plan. If they do not vote on this plan and adopt the plan by March 15th, you can lose your immunity. And that, sure as we're all sitting here, March 16th, somebody's going to come knocking on the door and file a lawsuit to get a builder's remedy. So it's critical that the board vote on this plan. After they vote on this plan, we'll then talk about the ordinances and what they say in terms of the adoption, because they are also the board is obligated to do what's called a consistency review to show how this is consistent with the newly adopted housing plan. The governing body is then obligated to vote to endorse this plan and make sure it gets filed prior to the 15th of the month. And that's the deadline spelled out in the Fair Housing Act and the state legislature, for God knows what reason, selected March 15th as the drop dead date. So that's in, I know it took a little more than 20 or 25 minutes, but I hope it explained in some detail how we got to this point for Ramsey and what the next steps in the process are. And with that, I guess I should first ask the board if they have questions, and then we'll turn it over to the public for questions.
Yeah, thank you, Mr. Burgess. I think what we'll do is we'll open this up to any questions from any members of the board. Once we go through that, then we'll open up to any questions or comments from members of the public. So, Mr. Burgess, you mentioned that the fourth round, the RDP obligation for Ramsey is 26 units, correct?
Correct.
And Ramsey has fully satisfied that with a combination of a couple of things. The Ramsey housing site, I think the new zone at Constantine Drive, the zone in 425 Island, as well as, I guess, the proposed overlay zone on North Franklin. Between those four, and I guess some bonus credits also you have in there.
Yes.
That would then satisfy the 26 units that the town is required to meet.
Correct.
So, once that's satisfied for these other overlay zones, that's there for the larger number, the borough has no obligation at all to satisfy any of those numbers.
Correct. All they are obligated to do is put in overlay zones to address 25% of that unmet need number.
Okay, thank you. You talked about the process. Maybe we can go into that a little bit so the public kind of understands how the process works with Fair Share. So, maybe you want to start with just from start to finish. Sort of how do you get from them coming up with their initial number to eventually the settled number with them?
Yeah, and this is probably the most unfortunate step in the whole process, because the state legislature created this as a court process that got the lawyers involved, and no offense to Bruce, but once it became a court process, everything was then going to be done behind closed doors, because if you did everything in the public, Fair Share would be sitting in the audience listening to what your strategy is going to be. Every developer would have their attorney sitting in the audience listening to how you're trying to deal with the issues, and then they would do their own strategizing to figure out how to best that. So the process demanded that municipalities do this in closed session, behind closed doors, so the other side doesn't get wind of what the municipality strategy is. And that's unfortunate, because up until now, under the prior rounds, it was a much more open process. So that essentially was the beginning of the process. As part of the process, once the municipality adopted its initial housing plan, and they had to do that by June 30th, the regulations provided that any objector could file an objection to the plan during the course of that summer.
And who can those objectors can be? Anyone, property.
It could be any property owner. In some instances it was, but overwhelmingly, as you heard me say earlier, it was Fair Share Housing Center and developers. The Fair Share Housing Center filed 400 objections. There are a total of 700 objections filed, so the rest were overwhelmingly from developers.
And once you're an objector, you're now part of the process as far as the settlement goes.
That is correct.
So in theory, if you had, let's say, an open discussion about various parcels in Ramsey, and developers sitting in the audience, and you were talking about parcel A or parcel B, they would now become in theory, they could become objectors because they know you're talking about their parcels, making them now subject to this whole process.
Yeah.
And Fair Share would kind of force you to also include those parcels, because now they know someone's out there looking to develop other parcels as well.
Not only that, those developers were then knocking on those people's doors to see if they could get a contract to buy the property if they can get the property rezoned at a certain level.
It's not, Fair Share says, for example, we want 10 properties. Okay, there's other objectors. We'll take 8 because there's 2 others. It's, we want 10 plus what all these various other objectors are going to want as well, as part of any settlement.
Correct.
Like Fair Share is not going to negotiate and say, we're going to take less because you have 10 other objectors. They're going to say, we want what we want. And you deal with the other objectors by giving them what they want.
Right, because in the problem, especially for towns in Bergen County, as an example, because we are all unmet need vacant land adjustment communities, there's always this large number of unmet need. So developers would be arguing, we could help you meet the totality of your obligation. And so, the goal line would be constantly moving in that direction. And, that was why it was important to go into closed session to make sure that didn't happen.
And when you negotiate with Fair Share and the developers, it's not they look at at what's realistic as far as the development, right? Like
no, and that was the bigger problem, because Fair Share, as I said earlier, they don't have licensed planners on staff. They're basically attorneys. They have who would only see that you're not meeting your obligation. And oftentimes you would hear them say, you have such a large obligation, you should consider 25 units to the acre where you are proposing 6 or 8 to the acre. Because in that way, and only in that way, are you going to address the significant portion of your obligation. And when you would point out that 25 to the acre just wasn't reasonable, because sometimes they were pointing to sites that were environmentally constrained, and they would say, well, you build on a smaller portion, just go up. Or, I guess my favorite story is in Saddle River, where they argued that, and I take this with a grain of salt, because we were all very, very busy, and, there was limited real analysis, I felt, on the part of, some of the objectors. And we had an instance where, and we talked about this in public in Saddle River, so it's not like I'm saying anything new and different. But at one point we received a report that said there was a site in our 3rd round plan that had never been developed. It was zoned for 5 years, so therefore this no longer represented an appropriate site. And you have to consider you have to find a different site to make up for that number of units that would have happened there. We had to write a report in response, and the report, amongst other things, said, if you turn to page 33, you would see a photograph of the affordable housing under construction. And if you looked at page 36, you would see a photograph of your boss at Fair Share at the groundbreaking ceremony. Just showing that they would provide information without really knowing what the housing plan said. And it was infuriating. But that's what we were dealing with. And it's unfortunate.
And I think you said before, what Fair Share looks at is 2 things, really. Proximity to public transportation.
Yes.
And proximity to highways, or access to highways.
That's the primary focus.
Okay. So if you, for example, went to Fair Share and said, I got an acre over here, I got an acre over there, over here, none of them is in proximity to any of this stuff, they would just say, doesn't work, go find something else.
Oftentimes they would, except for those municipalities that didn't have any train station or didn't have any major highways going through it. They would come up with something else as to why you still had an obligation and had to address it. But where there is a train station, mass transit, and where there is a highway with an interchange, that's where they were always demanding affordable housing be placed.
Right, and as part of the 4th round here, it was, I guess you said they started with a larger area on island that they initially wanted, and Franklin Traffic as well. And it was negotiated down to a smaller area. And these negotiations is never that we'll give you a different area in exchange. It's we want what we want, and we're not gonna. We'll take that plus something else. If you're gonna give us something else.
Yeah, because they, they're not familiar, especially recognizing that they're located down in Cherry Hill. They're not all that familiar with northern New Jersey. So all they're doing is looking at aerials and going, oh, there's a train station here. Look at Island Road, we'll just provide the housing there. And at a high density because there's a train station. And they came in at a significantly higher density initially for what they wanted to see on Island Road. And they were talking about much taller buildings than we ever wanted. And it was only through the adjudicator, and the judge who recognized that it seems a little out of character with what it should be, what the development should be.
So Fair Share, when they negotiate these, they don't care really whether it fits within the character. They're really looking at numbers, areas and numbers, and you have 424 that you have to meet, and how much can we put where to get to that 424?
Yeah, and quite frankly, it was often as the timeline kept shrinking, or a decision had to be made, it was who's going to blink first.
Right, because my understanding is this is statutory. Statute says you have to do something by a certain date, and there's no leeway. It's not like a town can say, we missed it by a day, we missed it by two, what's the big deal? When it's statutory, it's either meet the date or you don't meet the date.
Yeah, and that was in large measure a huge problem, because the legislation says March 15th. The legislation said June 30th. Then it gave a certain specific period of time for objectors to file. You can't, municipalities or the program can change the legislation. So everybody was really locked into these dates.
Yeah, it's sort of like, you sometimes hear when, judges are sentencing someone and they say, I'm stuck with the guidelines that the legislature proposed. Here it sounds like it's kind of the same thing. These are the dates. You have to meet the dates, or you then lose your immunity, which we'll get into that in a second. But it's not like we could say, well, give us an extra week, give us 2 weeks, give us 3 weeks, whatever it is. If Fair Share knows that. So they know that every town is stuck by these certain dates. So the closer you get to those dates, probably the less they budge when you talk to them.
In some instances, that was true. In others, they relented a little bit, recognizing this is not as good as they're going to get, because the municipality showed that we're drawing this line in the sand. Yeah. And if you could prove that, you're going to be tough about it. They sometimes backed off. But also, I want to point out that what you just said about the time frame, that was part of that legislation from the 20-some municipalities that was recently decided, because they were asking for an extension of time past March 15th, because it was such a truncated time period to work in. And, they lost 3 or 4 times in court. And then
5 or 6.
5 or 6. And then Justice Alito last week refused to accept it for the federal Supreme Court as an issue. So that really, I think, ended that issue.
Okay. And I know some people ask this question: had that been successful, even if you don't join that, it still applies to all the municipalities in town, in the state.
Correct.
Okay. So I think you talked about before builder's remedies, because I think that's the other aspect of this, which I think the board, needs some clarification on. So we talked about the process. We talked about, if you meet the process, you have this immunity from builder's remedies. My understanding, basically, of what builder's remedies, and correct me if I'm wrong, is that you basically lose the right to control the zoning in your town. A builder can come in and say, you have an unmet need. I have the ability to satisfy all or a portion of that unmet need. Here's what I propose. And it doesn't matter whether it fits within your zoning, whether the height's right, the setbacks, whatever it is, that they can go petition the court to say, the town has not complied with its requirements. Therefore, I'm going to come in and I'm going to develop property X. And this is how I'm going to develop it, and the town's going to get X number of affordable housing. Forget about what the zoning says. This is what I want to put and where I want to put it.
In large measure, that's correct. But there is a provision in the legislation that does also talk about land use compatibility. However, there's a lot of case law that makes that a very flexible concept. So, as I said earlier, if you're a 2.5 story town, it's unlikely somebody's going to get a 20-story building, but you will get something higher than 2.5 stories.
Right. So using Island Road as an example, because we have I think a prime example of the lumberyard site where we did have a developer many years ago come and seek to develop something there that at the time the board was not comfortable with, I think, on the height and the density, and he withdrew his application. In theory, that developer could come back if we lose the immunity because we don't comply with this, could come back with something even more intense on that site, higher, more dense, and there's really not much that the town can do to stop them.
Yes, because and you see that throughout the county, where oftentimes you're seeing 4- and 5-story buildings popping up, where there's no similar heights nearby. But those judges are making the decision that because you're not addressing your affordable housing obligation and because you have no vacant land to speak of, we have to go somewhat higher. And in some places it becomes 6 stories or 8 stories. It really is, site specific. But that's what you're seeing, taller buildings starting to pop up all over the county.
And this would, I guess, also affect each individual lot as well. Because right now, the overlay zone, as I understand it, you have to have 2.5 acres, and you have a certain density for that. If the town was to lose its immunity, and the Borough of Ramsey, they could pick a 1-acre site and develop on that 1-acre site something that is not zoned for right now, and is much more dense than what even this overlay zone.
That's correct. In fact, Fair Share originally wanted a 1-acre minimum. That's what they were pushing for. And we just said absolutely not. We refused to budge on that issue.
Okay. So, and that applies not just that applies throughout the town, right?
No, it's only in
the builder's remedies.
Oh, yes.
Yeah, it would apply anywhere in the town where they could find someplace that it's a residential zone and they have an acre or whatever it is and they want to build whatever they want, even though it's not permitted. Basically, the town loses the ability to control its zoning in that instance.
Well, again, East Saddle River is a good example. What's referred to as the Rosie O'Donnell estate on East Allendale Road. It's surrounded by single-family housing, but on that estate, they're now going to build, I think it's 48 townhouses with some affordable units. A lot higher density than the 2-acre minimum zoning that Saddle River has.
Any questions for any members of the board?
Mr. Burch, I have a question. About the borough-wide mandatory set-aside, that's your last row on the unmet needs slide with the 424 units. So right now we're at about 25% of the unmet need.
Yes.
And then we have that borough-wide mandatory set-aside, 20% with TBD. Is there an expectation that we have to get somewhere between that 30 and 50% number that you've been hearing of, or what is the requirement that the fair share housing should expect for us to meet that?
Well, we have a settlement agreement that accepted this, so we don't have to go to 30 or 50%.
Okay.
They accepted the 25% they given.
Okay. So would that be credit later down the road if we had when the 5th round comes?
Unfortunately, there probably will be a 5th and a 6th and a 7th round. Yes.
So that can be rolled over if we do have greater numbers?
I'm hoping that the cooler heads will prevail and there'll be an adjustment in the formula to determine what obligations are. I think there needs to be an acknowledgement that fully developed municipalities are in fact fully developed, and you shouldn't make everything look like Queens.
Thank you.
No offense to anybody from Queens.
Joe, that was going to be my question. From your experience, it seems like they move the goalpost every time they go around. This fourth round, does this end at 2035, and then there'll be a fifth, and a sixth, and a seventh, and an eighth?
Presumably. They're supposed to do every 10 years. And the legislation doesn't say it stops at a certain point. So unless, and I also say this at a lot of these public meetings, it's not the governing body here that you have to talk to. You got to talk to your state legislatures. They're the ones that put all this into motion. So find out, if you don't know who they are, find out. You had a great letter writing campaign for this. Do it to them.
Joe, if we miss the opportunity and we're subject to builder's remedy, and there's an area that is up for sale, and the builder gets it, is there a minimum acreage for them to develop, or it's just whatever they can fit into that stamp of land?
It's usually roughly 1 acre is a minimum. It's really like 0.86 acres that they have often used as a bare minimum, which is a little less than an acre. And that would really wreak havoc in this Island Road neighborhood, for example. That was the benefit of mandating 2.5 acres as a minimum, because it's difficult to accumulate, that number of, for the most part, that number of lots to come up with 2.5 acres, because half of the lots in the area are only 1/3 of an acre or less.
Thank you.
So on this Island Road, it seems to me there would be an arduous job for a developer to try to put together enough an acreage to build anything that we can accommodate affordable housing.
It would be difficult. I'm not going to say it's not possible. I don't want to give anybody the false impression. It's really up to the homeowners in the areas.
Can you get the numbers again? You said there's only one lot at 2.5 acres, and then you said half of the 30 lots are 0.5 acres.
No, there's no more than 1/3 of an acre.
Okay, not more than 1/3 acre. And there was another?
I think there were 4 or 5 lots that are that are more than an acre.
Thank you. Thank you.
Any other questions from any members of the board?
I have one question. When all of this is being discussed, wherever it's all being discussed, any discussions around the implications to schools or services when more people are in the neighborhood, or is that can just kick down the road?
That can, unfortunately, is picked up and thrown down the road.
Thrown down the road.
The courts have consistently said that's not an issue when it comes to affordable housing. If you have the services, you're obligated to provide the services.
There's case law that a municipality tried to use as a defense. It said, we don't have sewers. And they said, yes, you will. You'll put them in, but it's affordable housing.
And water too, Roger?
Water, schools, infrastructure, police departments, etc. They cannot use those as a defense to the affordable housing and the requirements. Just to follow through with this, you've been a planner for a long time and you understand New Jersey law. And the municipal land use law originally basically is a document, as I understand it, and have lived with, that really permits home rule.
Yeah.
And that's why towns have a planning board and have a zoning board to control their planning and their development of a municipality. And during the course of not only affordable housing, like correct, but some of the other mandates that have come out of the state, home rule's been chipped away.
No, significantly.
We had the residential site improvement standards, which every town now has to comply with, which talks about how big a parking space has to be, how many parking spaces you need for a development. And it used to be that the towns could have that in their ordinance. It was taken away. In the past, we've had ordinances that control what type of drainage systems we would have. And then we had stormwater management acts that come out, and all towns have to comply with that. Good or bad, we've had ordinances that controlled trees and things like that. We now have an ordinance that's come out of Trenton for that. So it's not just this, but this is the one that really hits us between the eyes.
Right. And don't put aside the Highlands Act.
That's right. Okay. Yeah.
89 municipalities come under the Highlands, and they told towns that were put in the preservation area that you could only build one house for every 25 acres.
Right.
Now, if you're a property owner thinking this was your nest egg for retirement, and then all of a sudden that's what you're told.
And just to clarify, this whole procedure has been governed by the courts. In fact, Borough of Ramsey has a docket number, and every municipality has. There's a judge in Bergen County, besides the 10 judges, there's a judge in Bergen County that oversees all of this to make sure that we're meeting the requirements and we're doing it on time.
What's interesting is it's just really coming to light. After the program judges made their decisions just recently, and that process has now ended, and now we're finding, because I got 3 calls this week from the program that we've now scheduled fairness hearings on the plan with the vicinage judge. And that was never really contemplated as part of the process. But all of a sudden, there's going to be a formal trial. And these are not Zoom hearings like we've had with the program. These are in-person hearings where there'll be testimony given and objectors show up and cross-examination and objectors present their own experts. So this process is really not ending anytime soon.
And correct me if I'm wrong, but a lot of the affordable housing, viewpoint from a planning standpoint, mass transit is a big item on the list of where this housing should be.
Yes.
And from what I understand, you telling us this evening, that was first and foremost in Fair Share Housing's approach to this, that could never be taken off the table. That was a given, that they wanted something done near that train station.
Yes, and it's primarily because it's also talked about in the state plan. So they have that to fall back on.
Right. And we recognize the train station on Route 17 was state mandated also. It's not anything the municipality had anything to do with.
Yeah, I think they condemned the property and built the train station. It was not the municipality that did that.
Thank you.
Any other questions from any members of the board as to Mr. Burgess? Okay, so what we'll do, we'll open this up to any questions or comments that any members of the public have. Come up to the podium, give your name and address.
Let's take a 2-minute break.
Okay. All right.
Thank you.
All right. We'll come back at 9:05. That's fine.
Yes.
I was just curious.
And regional subdivision stuff. I was here, and we were the first ones to do regional subdivision. We got that money overseas. And then the other thing we did at that time, it was a driving range. We're from Appalachia. Okay? We drive out. And then there was good money. That's 8 weeks. Okay? And that's when we was government. So since 9/11, we had to develop back in the day with legislation. They worked with
T-Nex not doing it, huh? I don't know what they're doing. They're at yeah, that's just about the zoning. I don't see it. They voted to allow everything now. It's all rezoned the place. Yeah. They have a number. Ringwood, I don't know what Ringwood's doing.
No, it's not. No, it's not. They were ruling for that.
100%.
Yeah.
You were doing it.
They don't know exactly. And I was giving this.
They just walked out. You made it out of that.
What they did, I was talking about
Oh, and Hill Street. That got the, yeah. This got denied. Hill Street, they tried to put a bunch of units there and it got denied. That one, the street was too narrow.
I live on a 5, that's so I really see it. It's already garbage.
What train station? Never on the highway. Oh, really?
Having to the Rams,
Yeah.
Sometimes we get walk home.
Is she gonna turn back on? Okay.
Bruce, I'm just gonna get all my properties 3 acres and donate it to my guy. Because the park. Good luck. I do it that all the time. Section 164 F, transportation projects. It's like you just touch the corner of the park. And I'm using it. Process will take a year. Oh, yeah.
She only had 4 car garage. The car elevator wasn't there anymore. So the first time I ever was in high school, so I had a group project. We went to the house on the river. Hey, we'll take the elevator. And I'm like, no, we need an elevator. We got an
Exhausted, like past my bedtime. My kids are home. Yeah, he's like, sorry, man.
All right, we're gonna go back on the record. Ms. Lupo, can you just do roll call before we start?
Councilwoman Mason? Here. Ms. Amy? Here. Mr. Barback?
Here.
Mrs. Wonderful?
Here.
Mr. Begoni?
Here.
Mr. Bauer?
Here.
Chairman.
Here. We're going to open this up now to any questions or comments that any members of the public have. Like I said before, so that way everyone has an opportunity to speak with any time restraints people have. We'll give everyone 3 to 4 minutes initially. You certainly can come back at the end, but I want to give everyone at least an opportunity to speak, have the opportunity to speak one. So give your name and address for the record, and then you can ask your question to Mr. Burgess.
Jamie Stevenson, 521 Island Road. Just want to start off by thanking you for your thorough explanation.
Just to interrupt you, we're going to have everybody sworn in. It's one of the rules the state has. So if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth and nothing but the truth?
I do.
Thank you.
Again, thank you for the thorough overview. Much appreciated. And thank you for allowing me to speak this evening. So I know you've emphasized multiple times, part of the rationale for this location is due to proximity to transportation. But I did want to just call out some other factors in some documentation that I'm sure you are very familiar with. So I would like to submit a copy of Section 2, the goals and objectives from the board's 2021 land use plan element, if I can approach.
Sure.
And actually, I'm going to hand off another document, the Fair Share Housing Development Effectiveness Plans as well. And I have other copies if board members want. I can hand those out. Anybody need them?
Looks vaguely familiar. It's got my name on it.
Yeah, I was going to ask. I was like, I know you, I think we addressed this before, but to confirm, this is your document, right? Written by your office?
Yes.
Yes. All right. So if we turn to page 11, I'll get my copy out here, of the plan. And we look at 2.2 Borough of Ramsey land use goals and objectives. Would you mind reading the policy statement for goal number 1, please?
The borough recognizes that one of its most significant attributes is its unique land use arrangement, one that's characterized by attractive, detached, single-family residential neighborhoods with a distinctive suburban flavor. The plan's land use recommendations are designed to protect and reinforce the prevailing pattern. It recognizes the established densities in the borough's residential neighborhoods and precludes the introduction of incompatible non-residential uses or intensities of development into these areas of the borough.
Thank you. And then if we could flip the page to 12 and if you don't mind reading the goal number 7, please.
The goal with the policy statement?
I'm sorry, the policy statement. My apologies.
The borough seeks to encourage a limited level of infrastructure improvement to accommodate local needs. The addition of new facilities that may be utilized to support higher levels of development than considered in this plan is discouraged. The borough's land use policy is explicitly designed to discourage infrastructure improvement projects that would encourage a significant increase in the carrying capacity of the land and consequently result in increased pressures for higher levels of development.
Thank you. So now that we've looked at these 2 policy statements, I'm just asking, how does this increased intensity of the use on Island Road reconcile with these 2 policies?
In large measure, it doesn't. But the problem is that document was written in 2021, and the program's 4th round legislation and regulations occurred in 2025, and it really was a game changer in terms of protecting the municipality as we would have liked back in 2021.
Yeah, understood. So I guess my point is, from a procedural standpoint, shouldn't the board reconcile the policy goals and statements of the housing element before we proceed any further?
No, typically what is taking place is the municipalities are adopting the housing element because we have this deadline coming up, and then subsequently reconcile it in some fashion by amending the land use plan after March 15th. And the program judges have recognized that there's only a handful of us planners that are doing this, and we just didn't have the time to reconcile. Now, I will say that in large measure, I would think that when we go to reconcile, we're going to point out that we've been forced to do this by virtue of the kind of numbers that were given and by the way the process has played out. Not that we want to just roll over on this issue.
Understood. Thank you. Is that my timer?
No, you can keep going.
Okay, thank you. So did the board adopt a written finding explaining how the Island Road overlay preserves the character of the neighborhood?
No.
Okay. So my next set of questions are based on the developing effective housing plans in the fourth round. This document, for everybody that's unaware, was issued by the Fair Share Housing Center and the Housing and Community Development Network in December of 2024, which I know you kind of discredited this group a bit with not having the licensure, but nevertheless, they do have this written documentation, you know, providing and outlining, you know, ways and objectives of going about this planning. So, was this written by the same group that challenged the 2025 housing element and fair share plan that this planning board council approved? Okay. Did you review the document and guidance in it before and after the challenge?
I had read it when it came out. I was curious as to what they were saying. It's curious that here's a group that's never prepared a housing plan, but they're the ones telling everybody how to prepare housing plans. This is the group that has never been to a meeting like that, like this, where they've had to defend the position that they've taken. And I guess it's somewhat ironic that you present this when they're the ones that wanted even higher densities in your neighborhood, or a smaller lot size, and a much broader area than we ended up being able to achieve. In reading this, I found that in large measure, it's a fairly straightforward rendition of what the legislation is. I was amused that in 32 pages or whatever, 34 pages, whatever it is, there's 2 paragraphs about the vacant land adjustment process. Because to me, especially for Bergen County and Hudson County and Essex County, that's the key to this whole process. And I seem to have been given kind of short shrift in all this.
Okay. Well, if we turn to page 13, I know not everybody has access to this document, but this, you know, it kind of gives a guide to municipalities on how to prepare a housing element and fair share plan. So I was just hoping that we can quickly, I know we're running out of time here, but there's 3 points I wanted to make here, or I guess highlight, or that they made that I would like to highlight. Would you mind reading just those flagged bullets there? There's 3 in column 2, page 13,
Sure.
Please.
One is analysis, and this is under what should be included in the housing element and fair share plan.
Yeah.
An analysis of the municipality's demographic characteristics. Secondly, consideration of the lands most appropriate for construction of low and moderate income housing, and the structure most appropriate for conversion and rehabilitation for low and moderate income housing, including land proposed by developers committed to providing low and moderate income housing. And then the third component is an analysis of the extent that the municipal ordinances and other local factors advance or detract from the goal of preserving multi-generational housing continuity.
Or family continuity. Well, thank you. So to those points, and living on Island Road, you know, our neighborhood is a viable, established residential area characterized by modest homes, long-term residents, seniors, young families, and first-generation homeowners who have invested in maintaining and improving these properties. So my last question is whether or not you have performed any of this type of analysis on the Island Road overlay.
We had originally, when we put together the June housing element and fair share plan, we had not included this area initially. It was Fair Share who came back when they objected to the plan, saying you should be designating this whole corridor for affordable housing at a high density. And that's what forced our hand. And we're at a disadvantage, so to speak, because there is the train station right there.
Okay. There's also a train station on Main Street. But thank you. I guess you answered my question. So the answer is no. The analysis, whether it was by the board or by your team or Fair Share Housing, it was not done.
No, the answer, I think, is that we had initially rejected providing this overlay here. They forced the municipality's hand by their objection.
Okay. So, but neither party did an analysis.
No, I think we did an analysis.
Oh, okay. So
by determining that
okay.
we should not be
Okay.
designating it initially. But when the objection came, they forced the municipality to consider a segment of the corridor. Because originally, when they objected, they wanted a much more extensive area to be included at a higher density.
Got it. Okay. Well, thank you. That's all I've got. Appreciate it.
You're welcome.
Thank you.
Thank you.
Mr. Burgess, just to clarify something, the party or the group that prepared that, I'll call it the presentation, that Mr. Stevenson provided you, they're the same people that you guys were negotiating with.
As the ones who prepared this document, yes.
Right. So in their document, they're saying one thing, yet in their negotiations, they're taking a position contrary to their own document.
It appears that way, yes.
Okay, thank you. Good evening.
Good evening. Hi, I'm Melissa Roche, R-O-C-H-E. I live at 480 Island Road.
Raise your right hand, please. Do you swear or affirm the testimony you're about to give you the truth and nothing but the truth?
I do.
Thank you.
Yes. Thank you for allowing me to ask these questions. I'm just going to be touching on on alternative compliance mechanisms. In the interest of time, they're going to be mainly yes/no questions. I did time myself when I practiced it like 4 minutes, so hopefully I get through it. Although I did add a question or two during this
I won't hold you to it.
discussion. Okay. So regarding any municipality's affordable housing obligations and specific to settling the challenges to Ramsey's fourth round proposal, is it correct to say that a municipality should be able to use a multitude of mechanisms, not just the types of overlays proposed here as R5E and R5F, in order to achieve compliance and settle challenges?
I would say that your statement is more reflective of how one addresses RDP. Typically, for unmet need, you do overlay zones because that way the underlying zoning also still is enforced. So if you wanted to, say, add on to your single-family house, you could. If it was a simple inclusionary zone, you wouldn't be able to do that. You would need significant relief from the zoning board because in an inclusionary zone, you only permit, say, apartments or multifamily or townhouses, not single family.
Okay, so I feel like you're going to curtail a lot of my questions, but the next one's kind of important. So as far as you can tell,
can you speak up a little bit?
Sorry. As far as you could tell, was the Fair Share Housing Center aware there was a second train station in Ramsey?
They were aware.
Okay. Is there a reason why no overlays were considered anywhere near that area?
They first wanted to do an overlay in that area as well. It was not one or the other. They initially wanted both.
Okay.
And we fought that.
Okay. And then I guess yeah. So I also, I guess, want to understand, in these negotiations, it sounds to me, and am I understanding correctly, the Fair Share Housing Center can point anywhere on a map that they like, say, we want that, and the town hands it over. The town hands it over in order to settle a mediation. Is this pretty much, because that's what it sounds like.
No, not at all.
They said, we must have this. I mean, yes, you negotiated down from what they said, but
we
gave them
negotiated down.
Mm-hmm.
In some instances, we just simply rejected what they were asking for. For example, the other train station. For example, the entirety of Franklin Turnpike. For example, extending the overlay zone farther south along Island Road. That's not all that unusual. We've done that in other municipalities as well, where we just say what you're asking for is totally inappropriate and it doesn't comport with sound planning design criteria. So there are times when you just can't fight the fight. But when you're unfortunately next to a train station, it makes it more difficult.
I wish you knew why I was by a train station. It's okay. If I had known, I would never have purchased this house. Thank you for your time.
Alicia Carbone, 50 Ferguson Place. I also live at 46 Ferguson Place currently.
Right here. Swear or affirm the testimony about to give will be the truth and nothing but the truth.
Yes, I do.
Thank you.
Just so everybody knows, my lot is a half acre, so I don't fall into what you said we were defined as. Okay, so I'm here to be creative, right? That's what we should be doing, I think, since we have no options and we have this very strict deadline. So, Mr. Burgess, can you describe for the public what an accessory dwelling unit is?
An accessory dwelling unit is typically, for example, a detached garage in your backyard, or you just want to build a small apartment structure in your backyard. Sometimes I've seen on split level houses, they take from the rear, they will take the basement area and make that an accessory structure. Why that's not popular is because a lot of people don't understand that you don't get to select who lives there. It's a lottery. So some people are not as thrilled over that idea.
But you prepared the housing element for Princeton, correct?
I did one, but not for the fourth round, no.
Okay, well they do allow accessory dwelling units there. It's a pretty nice town, I would say, right?
Yeah.
They're also referred to as granny flats or in-law suites. I have 2 small children. That would have been a dream to have my mom next to me or my in-laws next to me or anyone who, if you've ever had to find housing for your parents who are on a fixed income in this world, it's not easy to do, right? So that would have been a huge benefit to my family and I'm sure others.
Could I just offer a comment about Princeton?
Sure.
Because in all the housing plans I've ever done, it was the only place where we said we're doing the required number, and people would get up and say, why are we only doing the minimum? We should be doing a lot more.
Right. So do you know how many municipalities have local ordinances that allow accessory dwelling units in New Jersey?
No.
8 municipalities.
I was going to say, it's not many.
No.
We've had probably the most success in Fairfield, where there's a cap on the numbers. You could do up to 10.
Okay.
But in Fairfield in Essex County, we've had such a successful program. I think they've now done 25, and the courts have allowed because they're doing a great job at it.
Yeah, and they also count towards credits for the fair share housing, correct?
Well, yes.
Obligation?
Yeah, but again, usually it's capped at 10.
Right. Okay. Well, so another thing to touch upon so everybody knows, in New Jersey, there's currently no state law as it relates to accessory dwelling units. There's some that have been proposed, but none currently. So since there's no state law, municipalities have full control over regulating these ordinances, correct?
No, you still have to follow.
There's a few things that you need to follow, but you do have control over the characteristic of the house, the size, the density, correct?
Yes, okay. Correct.
All right, so can you point me to a chapter in the master plan that's dedicated to accessory dwelling units in Ramsey?
I don't believe we have one. I don't believe the municipality wanted to pursue accessory apartments.
Okay, so then there's no area in the housing element that analyzes borough-wide accessory dwelling units as an option.
Correct.
Okay. So we often hear the town is fully developed, right? Did you know that in the proposed overlay zone, 8 out of the 30 properties have an existing secondary structure? 4 out of 8 of them being in Ferguson Place alone. Right, I was actually wanted to put an ADU over my garage, and I was just told no. The reason for that is because in 1972, the borough released Ordinance 34-4.5, which states that the accessory buildings are not for human habitation. 3 years prior to the Mount Laurel Doctrine was passed in 1975, right? So I did some math. So per page 20 of the amended housing element, which I cross-referenced with the April 1st, 2020 census, there's 5,267 dwelling units in Ramsey. Does that sound about right?
Yeah.
Okay. Pursuant to page 20 of the amended housing element, which I cross-reference with April 1st, 1970 census, which predates ordinance 34-4.5, there were 3,618 dwelling units in Ramsey. Does that sound about right?
I'll take your word on that one.
You have a great chart, it really is. And it was correct with the census, so a win for everyone. So it's possible that 3,618 dwelling units exist in Ramsey that may already have an existing secondary structure. Is that correct? Potentially.
I'll say potentially.
All right. So do you agree that ADUs, if properly regulated and deed restricted, can count towards affordable housing obligations?
Yes.
Okay.
Certainly.
All right. And as been stated, to meet our fourth round obligations and protect the town from builders' remedy lawsuits, we have to come up with 424 units that meet the affordable housing requirements, correct?
No. We have to deal with the 26.
26, correct.
Yeah.
Yes, okay. So let's even talk into the future, right? We're being creative. Would you say that 3,618 potential dwelling units presents more of a realistic opportunity than the 30 homes on Island Road overlay zone, which are currently happily inhabited?
No. And the reason why I say that is that the density that we ended up permitting, that's likely to encourage more affordable units than the 10-unit limit on accessory apartments.
Okay, so we're talking about going, let's say, because a lot of towns are giving grants to people to build these units in their properties, right? $100,000 grants, correct? That's a pilot program currently in legislation. So are we thinking of building more than 3,618 units?
No, we're planning on building 26.
Okay, so seems like, all right, so the proposed housing element does not comprehensively analyze accessory dwelling units as a borough-wide gentle density, that's what it's referred as, strategy that would result in increased home values, decreased infrastructure expenditures, and enriching the lives of our Ramsey families, correct? We're not even going to contemplate it.
Correct. Again, because there's the 10-unit cap, and our obligation for unmet need was such that
Fairfield,
10 units didn't get you very much.
But Fairfield went to 25, and we had 26, so we could potentially only have to build one unit.
Fairfield is a unique situation. They had a very, very aggressive program. It's probably, and I know for a fact, it is the single most aggressive program in the state.
Okay. And is that 10 units or 10% of units?
No, 10 units.
10 units, okay. All right, so I can sell to a developer, but I can't build a studio apartment over my detached garage in Ramsey. Right? That's what we're all agreeing to here tonight? Would you say the town's inclusion of ADUs should maybe be reanalyzed for the next 10 years?
Yes. No, I've always been a proponent of it, but again, it's up to the individual municipality.
Thank you very much for your time, Mr. Burgess.
You're welcome.
Good evening, Jeremy Stats, 486 Island Road.
Raise your right hand, please. Do you swear or affirm the testimony about to give you the truth and nothing but the truth?
I do, sir.
Thank you.
Mr. Burgess, great presentation. I also want to let the council know, or the planning board know, I am a licensed architect in New Jersey. Okay, license number 21AI0205-4700. So on behalf of my neighbors, I've been really struggling with this over the last few weeks, coming up with questions for this council to help explain the process. I do appreciate all of your questions tonight. They have been excellent of Mr. Burgess. I wanted to focus on TOD for a few minutes. I've reviewed both of the plans since we got them last week, the 2025 housing plan, which you wrote, as well as the 2026 amended housing plan. One is 96 pages, the other 213, right? So the original 2025 report, which this planning board and council ultimately passed and adopted, as you mentioned, does not show any new overlays, right? I think you would mention that before. So only in the amended plan were the R5D and R5F overlays introduced, which are now being introduced as ordinances, excuse me. But at the time of original writing, you did not feel they were required, right, in 2025?
I was comfortable with the Recognize the June 25 plan was conceptual. We had a file that did not include any appendices. I was comfortable with the plan that we came up with. It was when we had to deal with the objectors that changed things.
And that answered my next question. So these overlay plans were created in response to litigation based on these challenges.
Yes.
Okay. Ramsey is a significant transit corridor. I think that's why a lot of us did invest here, right? 2 transit stations, as well as a significant amount of bus stops in Ramsey, right? So there's a lot of places in this town to get access to public transit. So I want people to realize it's not just train stations. We could be looking at corridors around bus.
Let me comment on that, because there's been a lot of discussion throughout this process with the program judges as to whether or not bus stops should count when the legislation talks about mass transit. And the emphasis has always been on train stations rather than individual bus stops.
The emphasis, sure, but anybody who takes the bus to the city knows if that's close to their house, that's what they're doing.
I understand that. I'm just telling you what the judges are saying.
Makes sense. You've answered a number of my other questions. Was transit-oriented development, which especially around Route 17 and Ramsey downtown train stations, was that a focus of your 2026 amended housing element plan?
Only to the degree that we had to deal with fair share on that issue. We had looked at the other train station and the possibility of providing additional floor of housing on the downtown area. That was not considered by the municipality for a variety of reasons, especially when Fair Share then started talking about multiple stories in that corridor, and that was just not acceptable to the town. And they backed off on that one.
But again, at the Ramsey Main Street station, we have 4 sizable parking lots that abut that station, right? Underdeveloped, blacktop. We're right next to downtown Main Street. There are numerous townships throughout New Jersey who are addressing sites like this with mixed use, with parking underneath, building up above, right? What the new overlays that were proposed are potentially relocating 28 single-family homes. Why is not more emphasis placed on 4 undeveloped parking lots in downtown Ramsey?
One thing, recognize that Fair Share was not backing away from one site if we did something else, because they were talking about the parking lots, for example. But in addition, when you're dealing with municipal property or DOT property, you needed to have a developer in hand. You had to have the pro forma and all the fiscal information available to present it and have it signed off on as part of the mediation agreement. And as you know, as an architect, that doesn't happen in a week or 2 or a month or 2. It takes a much bigger effort.
And that's the point I'm getting at. And maybe this is not for this round, but in 2035, when we all have to do this again, right, we need to be ahead of this. We need to be thinking creatively, like my other neighbors have discussed. And I imagine Missouri developers calling us, I'm sure they would line up to develop a parking lot around Main Street. So I'm more talking to this board to be considering larger picture here. North Franklin, that overlay was added as a result of the litigation, correct?
Yes.
That's not necessarily close to transit, right? What is the attractiveness of that overlay zone?
They were focused, Fair Share was focusing on the fact that there was some multifamily nearby, in that corridor, excuse me. And they talked about going down Lake Street and then over to 17, so it's not that far off from Route 17. That was their focus.
Walking?
Not walking, no.
To drive onto the Route 17 corridor.
Correct.
So it seems like there are a number of places in town that would also fit that description, right? Multifamily already there and close to our Route 17 corridor. So once again, for future rounds, I think we all have to be very aware of potential for additional lawsuits, frivolous or otherwise, that's going to force us to create these overlays. Because what I feel is that a pretty dangerous precedent is being set here, that for years to come we are going to have to rectify. My last thing, I'll pass it to my neighbors here. Sir, in the end, page 36, basically your summary of the 2026 amended housing element and fair share plan, you say, as detailed herein, the housing element and fair share plan can accommodate the entirety of the community's affordable housing obligation through 2035 in a manner that affirmatively addresses affordable housing need, while at the same time addressing planning concerns and maintaining the overall character of the community. My question to you and the board, that do you feel in such a condensed time frame, since these challenges were filed, that we've had to, or the town has had to respond to, do you feel that statement is still accurate? Were appropriate planning concerns addressed, even without other sites being studied and rejected? And is a proposed R5E Island Road overlay zone, by proposing this overlay zone, are you maintaining the overall character of the community through potentially 350 units that would basically displace 28 of my neighbors?
All I can say is, I think I said it earlier, our experience with a number of municipalities and overlay zones, we've had the discussions about, if you want to maintain the character of your community, don't sell to a developer. And if you recognize that, you'll continue to maintain the existing established character of that area. I mean, I know that might be asking a lot of people, but if you really take pride and love your neighborhood, that's what you would do.
We're all here, I think, because of exactly
that. And I think that reflects it.
Thank you for your time, and thank you for the great questions.
You're welcome.
Thank you. My name is Jamie Harsha Troy, Harshatroy. It's a mouthful.
Raise your right hand, please. You swear or affirm testimony about this will be the truth and nothing but the truth.
I do.
Thank you.
I am piggybacking on this conversation.
Can you state your address for the record, please?
Oh, I'm sorry, 11 Thornhill Drive.
Thank you.
I actually back up to the Franklin Turnpike all the way. I am going to piggyback onto that conversation, and you got a big head shake out of me on that one, the big no. And I'm going to throw out some experience that I have. I am a real estate agent. I'm very familiar with fair housing in various different forms. But I'm also coming to you as a former planning board member in Airmont, New York, and Rockland County. I can tell you that it is most certainly not up to the homeowners not to sell. In my experience, very large-scale overlays will almost certainly lead to predatory investors, door knockers, aggressive fear tactics from solicitors looking to buy and hold and rent the properties until they are able to acquire enough to build. The active solicitation is aggressive. It can be it can borderline on what we know as blockbusting. For those who don't know what that is, it's pushing people out in fear. And I've seen it happen. I had sold 15 homes within 1 year in a neighborhood that I lived in. I was part of the problem in that case, not intentionally. And I had actually stood up and had to speak in front of the Department of State because solicitation got so severe. So my question to you guys is, and a statement to you, is to get ahead of this. This looks like it's happening. I think we have kind of all come to that conclusion. So I would like to know what kind of protections you're going to put for our neighbors in place. Ramsey does not have strong no solicitation laws. We have to protect the neighbors against this type of mass solicitation. Some of my recommendations are no-knock ordinances, lists, rental registrations, because buy and hold property devalues the neighborhood as a whole, it devalues a town. LLC identification rules. We had to really get ahead of this in Rockland County because people are buying these properties under LLCs and then we can't find them. We can't find the owners. We don't know where they live. They live in the city. We can't get a hold of them when things go wrong. and other things to protect the residents in general. You know, I would get on it quickly because I am already familiar with a few of the neighbors having gotten letters for solicitation already. So that is my request. Look into your solicitation policies in Ramsey. Get ahead of it. It is very poor to minimal right now.
Could I make a suggestion?
100%.
I know there's minutes being taken, but you rattled off quite a number of things. If you could put that in a letter and email to
Gladly.
my address is on the housing plan.
Gladly. And this comes from experience. A lot of it.
I'm Councilwoman Cusick. We do have a no-knock ordinance in this town. You go to the borough website and register for it, and it is enforced.
And we don't publicize it when people get upset about that solicitation. We need to publicize it. We need to get it a little bit stronger, and we need to have lists in place, stickers. You can supply the townspeople with stickers.
Yeah, we have those.
Then publicize it a little bit. I think our communication in this town is a little bit mediocre. I think we can do better. And I think that if you get ahead of some of this stuff, it will then allow the townspeople and the neighbors to make that choice of not selling to investors. But it's not all on their shoulders. You can't put it all on their shoulders, because once these investors get wind of some of this and they start being aggressive, they will come out in force. And it's more about the fact that this overlay is large. If you had spread this overlay into various different locations throughout the town, I would be less concerned. But this overlay is very large, and it's in a location that's very close to commercial districts that are currently owned by investors already. So maybe it might be a little bit of a knee-jerk reaction on my part, but been there, done that. Thank you.
So, if I may,
Yes.
ask, if you could put what you had in an email to Mr. Burgess, and Mr. Burgess, if you could then share that with Ms. Lupo, and Councilwoman, because if you could look into how we publicize the no-knock ordinance in town.
Yeah.
Perhaps we have to maybe put it on the website on the front page or something along those lines.
Yeah.
And start getting ahead of your rental registries.
I prepare ordinances for the town.
Good.
So that's why
Perfect.
I really appreciate you sent me that.
Excellent. Will do. Thank you. I appreciate it.
My name is Linda Dunn. I live at 10 Amanda Court.
Swear or affirm the testimony you're about to give me the truth and nothing but the truth.
I do.
Thank you.
So I'm going to change gears a little bit, and my questions might be a little shorter based upon a lot of what has already been said. So, Mr. Burgess, am I correct in assuming, based upon your previous comments, that issues of traffic and safety were thrown down the road along with issues of school and public services?
No, the issue of safety is always there. That typically is part of the site plan review process. So, for example, if there's a poor alignment for a driveway or whatever, that's handled at that time. And plans can't be denied if they don't resolve pure safety issues.
Okay. So, yesterday, the planning board was sent copies of this report, which is a report from 2004 that was prepared by Project for Public Safeties prior to the building of the train station. We, at our request, I served on a committee back then for traffic calming, and at our request, New Jersey Transit and hired Project for Public Spaces to prepare this traffic calming report. Would you like a copy of it?
I have a copy.
You have it, perfect. Okay, so then you have probably seen that on page 7 of this report, it states some New Jersey Transit statistics that were collected in May of 2001, where they estimate that approximately 8,000 cars per day travel along Island Road. That was 25 years ago, before the train station was even built. You agree with that?
I believe it says that,
I believe it
yes.
says that, okay. And then I'm sure you're also aware, if you've seen the report, that on page 9, it refers to a speed study that was conducted in July of 2004 that reported a median speed of 34.4 miles per hour and an 86th percentile speed of 39.9 miles per hour, while that zone was still, as it is now, a 25 mile per hour zone. And then their conclusion in their report was that because of a combination of speed and crossing issues, very, very poorly and inadequately designed crossings, that whole corridor was deemed to be hostile to pedestrians and bicyclists of all ages. So their report has about 58 recommendations of things that the town could have done to calm traffic back then. I count 2 that were actually done. I have lived on my house on Amanda Court, where I can't leave my street without turning onto Island Road. And I've lived there for 34 years, and I can tell you not much has improved in 25 years. They made 2 improvements, but it is still a disaster. Speeding is excessive, and crosswalks are terrible. So, as part of this overlay, were there any considerations to traffic issues?
No, that wouldn't have happened at this level. What would happen is after the ordinances are adopted, the site plan review ordinance would also then be looked at to see if changes are necessary.
Okay, who would do that?
Probably my office.
Okay.
After the municipality.
So I imagine that if you've seen...
And they may very well bring in a traffic consultant.
Okay. And then is it up to the borough, though, to make the decision to actually implement those?
Yeah.
Because, as I said, there were 58 recommendations from 25 years ago, and 2 were made that I count. So is there any consideration of safe walking to schools, or is that all to be done at a later date?
That would all be done subsequently.
Okay. So, moving on to
Let me just add to that, because
sure.
As I said earlier in response to a question, at some point after March 15th, presumably the planning board would reopen the land use plan element and possibly another traffic safety element of the master plan, and look at stuff like that to see what would happen if these sites were to develop.
Right. Okay, well, and I'm glad you brought up the traffic element of the master plan, because there are a couple of recommendations and goals in the master plan relating to traffic. One is, the recommendation is to avoid zoning changes and zoning variances for higher density residential development or more intensive commercial development than currently permitted, to limit future increases in traffic volumes. And the goal is that future development and uses should consider the reduction in traffic conflict points to the extent possible. So do you believe that this ordinance 04-2026 with the R5E overlay is consistent with the planning board's stated goals and recommendations, which, by the way, were approved 13 weeks ago to the state, so very recently?
I'm sorry, what document are you referring to?
I am referring to, this is the traffic circulation, Ramsey traffic circulation and transportation element. It's dated November of 2025, and it was approved December 2nd of 2025. And my understanding is that this is part of the master plan that was approved by the planning board.
I see that.
Sorry.
Okay, this had not been prepared by our office, and for whatever reason, I never even received this.
Oh, there you go. You can keep that copy.
This is a copy for me?
That is for you.
Thank you. I saw this up here. I thought it was from our office. I'm saying I don't remember this. Okay.
So would you say that this overlay is consistent with those goals and recommendations that this board approved 13 weeks ago?
Let me read that in conjunction with everything else before I answer that question.
Okay, so in conclusion, what I would like to say, and it's really not so much to you, it is more to the planning board, is that even if the overlay gets approved, which at this point it looks like it probably will, and even if the high density never goes in, that Island Road corridor with Finch Park at one end and then extending through to the elementary schools is a traffic nightmare. These residents cannot get in and out of their driveways. I have a hard time getting out of my street to make that turn. The crosswalks are terrible, the lighting is awful, and some real substantive changes really should be made for that corridor. It's where, you know, our primary playground is at Finch Park, and that should be considered. And I guess I direct that to you, Councilman Cusick, since you're on the council and on Buildings and Grounds. Okay, thank you.
Thank you.
Good evening. My name is Brian O'Connor. I live on 464 Island Road in Ramsey, New Jersey, with my wife and my daughter.
Swear or affirm the testimony you're about to give me the truth and nothing but the truth.
I solemnly affirm. Yes, so my wife, my daughter, and I, we've been living in Ramsey on 464 Island Road since March 2021. And since we've been there have been 5 car accidents. So that's averaging like 1 car accident a year. And they're all happening in less than 100 feet, 75 to 100 feet from where my driveway is. So my question is, if during the overlays, has anyone performed a capacity analysis as well as other related traffic circulation impacts these sites might cause? How much are we looking at as far as apartments, buildings between now and 2030? About how many units altogether?
That's hard to say without knowing who's going to be selling. Nobody has to sell their property.
I know, but the developers seem to have like the upper hand. It seems like they have control to some extent.
Not necessarily.
Here. 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 Okay, so why don't you give your name and address for the record again, and then why don't you start over? I don't know what was picked up, what wasn't.
Sure. I'm Brian O'Connor. I live at 464 Island Road in Ramsey, New Jersey.
You're sworn in.
Okay. All right. So let me start over again. What I was looking for is, since they've already done the overlays, did anyone perform a capacity analysis report of the traffic? Because from what I heard, the 2001 was 8,000, and as I said before, I've been living here since March 2021. It's now March 2026. There've been 5 car accidents.
Yeah, we are not traffic consultants.
I know.
So, okay. Natalia had prepared a report that I just received, so I don't know what it says. So unfortunately, for me, your question is a little premature. I haven't read
No, well, according to the report, they were looking at, 350 units?
Yes.
So if it's 350 units, let's say each unit has 2 cars. Roughly, like, how many cars would you say would be on Island Road?
Now, usually traffic consultants will look at peak hour impacts. And peak hour impacts, typically a dwelling unit, it's like 0.6 units per trip, because people leave their homes at different times. For example, I'll leave my house at 7:30 to get to work. My wife will leave close to like 8:45 to get to work. So we're in 2 different peak hours. And that's what happens in traffic testimony. So they talk about it differently than just 2 people leaving a house, and so therefore it's 2 trips per peak hour. And peak hour is the critical indice that traffic consultants will use.
So right now, I leave home at 5:30 every morning. So when I open my door, between 5:17, 5:30, there's always a car driving by. So what I'm looking at by 2028, 2030, if we have 150 units up there, we're looking at 300 cars. I also observe over the 5 years, on Thanksgiving Day, the whole street is taken up.
Yeah.
All the way down to the train station.
Yeah.
So what I'm looking at when we have 150 units, 300, 250 cars, their family and relatives come over on Thanksgiving. We're looking at parking from Finch Park all the way to the train station or all the way to Interstate Mall. So, again, I'm looking for a cumulative impact report showing what, yeah, something in writing to say, okay, we look at this and it's good to go. We can see another 300, 500 cars on this road.
Yeah.
There'll be no more accidents.
This traffic report may have the answer.
I think we're on. Lieutenant, did PD go to generator power too then?
No, we're on. No.
Okay. Yeah. Okay, so she said we're good.
We're good.
Okay.
Okay, all right, so let's go back on the record. Roll call, please.
Councilor McCusick? Here. Ms. Staney? Here. Mr. Garbat?
Here.
Mr. Palumbo?
Here.
Mr. Reggiani?
Yeah.
Mr. Zavala?
Here.
Chairman Irish?
Here. Okay, Mr. Burgess, I think.
Let me offer this.
Mm-hmm.
In the third round, a tremendous number of housing plans had overlay zones. Very few of those overlay zones have ever been built. So the suggestion that it's definitely going to happen here isn't borne out by the experience elsewhere. And when I say experience elsewhere, I'm talking about municipalities in Bergen County that have overlay zones that have never been built. And quite a number of them that are higher densities than this. So while a few lots may develop over time, I don't envision that the entirety of the area would ever get developed. That doesn't help you from your problem, which is a safety issue.
Yes, and I have a daughter in elementary school.
Right, and I would suggest that if and when any lots are put together to come in for a development application, that's when this board, would be evaluating in detail the traffic safety issue and require developers to do the traffic counts. And the municipality might hire its own traffic consultant to do its own counts and look at all the safety considerations. But at this preliminary stage for the housing plan, that kind of analysis is not undertaken.
Okay, so can they still go ahead with a vote even though...
I'm sorry, say that again.
Can you still go ahead with a vote after I just mentioned that there were 5 accidents in 5 years? And we're looking at more units, more accidents in the future?
This board, I know you're not going to like this answer, but this board, to protect the municipality, has to vote on this document. They might deny it and not approve it, but that would really put you in much greater jeopardy than if they were to approve it and then look at some of the issues you're raising and possibly amend the document in the future. But they need to adopt this document.
Okay, so we're looking at... Okay. I'm just concerned about my daughter, my daughter's safety.
I fully understand that.
Okay.
So, Mr. Gunn, I just want to explain. So, whenever we have a project being built or being proposed, one of the things that this board always looks at is traffic. So, we looked at it at the other project that's proposed for the senior housing on Island. So, hypothetically, if there was a developer that came in and said, we want to build whatever on Island Ave, one of the things that this board looks at and takes very serious is traffic. So they would have their traffic study, we would have our traffic study. If the traffic studies show issues, they have to be addressed.
When was that one done, completed, that last report? When was the last traffic report completed?
Which report are you referring to?
Traffic, analyze the traffic condition on the island.
That was last year.
Yes, that was for 425.
Yeah, so that was what I was referring to was 425, where the senior housing project is. They had a traffic expert. I believe we had our traffic expert, and they discussed how many trips, because it's senior housing, it's a little bit different than, regular housing. How many trips would come out and what the added volume onto that road would be.
Was any done for 425?
Excuse me?
Was any done for 425 Island Road?
Yeah.
There was one done?
Yes.
Yeah.
And according to my neighbor here, she said that there was like 8,000 was the number of cars they said on that road.
No. So that was a study that was done 20-something years ago when they built the parking deck for the train station. And that was, I guess, a study that was done on how many cars go up and down Island. What I'm referring to is when we have specific applicants come with specific projects, we always have a traffic study done that tells us what are the counts, and more importantly, what additional volume is going to be added, if any, to the street because of what's being proposed. So if hypothetically there is ever a project that's for the board, that's something that would be taken into consideration. And if our traffic consultant says this is an issue, it's going to have to be addressed somehow. Whether it's a stoplight or whatever.
Can we take in consideration what I just mentioned again, the 5 years, 5 accidents? Because that's on my mind. Again, I have a daughter in elementary school, and again, it's within 75 feet of my driveway. Those accidents happen.
Understood.
Thank you.
If I could just, hi, Joe Carey, 498 Island Road.
Swear or affirm the testimony about to give you the truth and nothing but the truth.
I do. Just a quick follow-up question on that. I think the issue is not if the sites themselves have a traffic plan, but is there a comprehensive plan along the entire corridor, similar to what the PPS report was done in 2004? Site-specific plans, traffic plans, tend to be, they look at their site and they're just saying, this is what we're doing. And there isn't really taking into account the cumulative effect of this site might add a few cars and that site might add, not as few, but a little bit more. And then this guy says this, and currently right now, we have 2 sites. One's been approved. We have Ramsey Lumber, that could be a significant number of units and vehicles. And now we're looking at this other thing, and I think it's extremely important for the borough to be proactive on this issue and not just rely on the applicant to do the count for his site. And what's your site going to do when there's been long-standing cumulative issues along that corridor? Thank you.
Stephen Bennett, 36 Ferguson Place, Ramsey, New Jersey.
Raise your right hand, please. You swear or affirm the testimony about to give you the truth and nothing but the truth.
I do.
Thank you.
I'm referring to traffic and the 2004 study. At that time, the plans did not require a widening of Ferguson Place to get into the back entrance of the Ramsey Lumberyard. However, this time now you have the nursery on the other side of the lumberyard, which has no direct access off of Island Avenue that could sell and would meet the requirements of the 2.5 acres. And Ramsey Lumber would meet the requirements of 2.5 acres. My fear is that with all the additional traffic, they would need another means of entrance and egress out of this complex, which is only Ferguson Place, which would mean that our road would have to be widened considerably for the amount of traffic that would be coming in. Because living there for 24 years, I had to make them change the street to parking on only one side, because when I went out to work at 6 o'clock in the morning, I couldn't get through the street because 2 cars were parked on either side and I couldn't fit through. And a fire truck wouldn't fit through. So these are some of the considerations that I hope Because if the widening of the street will lower my property value. So, and I know I have resilient neighbors on our block that I don't think they want to sell, but a large residential complex is going to need more than one entrance where the Newcastle entrance is now to accommodate all the people going from that end all the way over to the nursery. Because I don't think you're going to knock houses down that are not part of this just to put a road in. I just would like that to be part of the consideration of reviewing these plans, because, like I said, that would reduce the whole value of that block considerably, because I would assume it would take most of the 10 feet on either side of the street to expand the road. Thank you.
Okay, thank you.
Hello, Stacy Tosney, 41 Ferguson Place, Ramsey.
Right here, please.
Thank you.
Swear or affirm the testimony about to give you the truth and nothing but the truth.
I do. Thank you. Good evening. Thank you. That was, first of all, the time that you've spent here and the details in your presentation was great. I appreciate that. So I understand the town has obligations under the housing element and fair share framework. And my questions tonight are not about whether or not the town must comply with those requirements. For context, my family has a close connection to emergency services. My husband serves as a career fire lieutenant and an EMT. So emergency response reliability is something that I take very seriously. My questions tonight are focused on whether this overlay location has been adequately evaluated from the standpoint of fire protection, EMS response capacity, and emergency access reliability. I'm asking these questions to help ensure the public record reflects whether these public safety considerations have been fully evaluated before advancing this overlay. Mr. Burgess, I have a feeling that this might not be something that you can answer these questions based on what we've already talked about, but I'm going to ask them anyway, if that's okay. If that's okay. Mr. Burgess, have you conducted or received any an emergency response time analysis for this overlay, including projected increases in fire and EMS call volume and response conditions during peak traffic periods?
No.
Mr. Burgess, have you evaluated whether emergency vehicles can reliably access and exit the neighborhood during peak traffic conditions or roadway obstruction scenarios?
No, none of these questions are easy to answer at this early stage because you don't know which lots would be combined to then determine how any application could comply with all the site plan design criteria that's already in the ordinance.
Yeah.
And that's what would determine a lot of the things that you're asking about.
Right. Okay.
So when an application is submitted to the planning board, it's required that copies of the application and the plans go to a number of different departments, including the fire department, police department, etc. And we have to get reports back from them to determine what is being proposed meets their requirements.
Okay. Have you evaluated whether the site complies with NFPA fire apparatus access standards, including roadway width, turning radius, and unobstructed access for fire equipment?
Again, the site plan design criteria address that issue.
Mm-hmm.
And it would depend on when the applicant files the plans for which properties, they would have to comply with those standards.
Okay.
Make sure that that's addressed.
That makes sense.
Just for what Mr. Whitaker was saying, we have had applications where they've done their radiuses with the fire trucks and everything, and we made them go back and modify it because what the applicant was proposing didn't work for the fire department or the police department.
Yeah. My husband says we have a great fire department here.
We do.
We do. Have we evaluated whether current fire and EMS staffing, equipment, and deployment capacity can support the projected density without increasing response times?
It's really two different issues. You know, the issue of personnel is a problem that many municipalities in this area are facing because the average age of communities is going upwards. We just did a study for Roxbury, where the average age of their first responders is now hit 60. Yeah, wow, indeed. And now they're thinking of whether or not they have to go to a full paid department.
Exactly.
And that's what other municipalities around here are soon going to be having to address as well.
Yeah. So, obviously, this question is probably not relevant, but I'm going to ask it anyway. Have you consulted with the Ramsey Fire Department regarding whether the proposed density and existing access conditions can be supported within the town's current volunteer response model?
No, we have not. We would be doing that on a site-specific basis when they come in, not at this early stage.
And has there been any evaluated simultaneous emergency demand scenarios, such as multiple calls occurring during peak traffic conditions, and whether emergency access routes and response capacity would remain reliable?
That would be assessed during a site plan review.
Okay. Given that planning boards are required to consider public health, safety, and welfare when evaluating land use decisions, can we confirm whether you have determined that emergency access and response infrastructure in this proposed location are even adequate to support the proposed density?
That issue again would be during the site plan review process, and that's when it's addressed.
It's I just wanted to definitely come up here and say that for the record, even in the future, 10 years down the line, or in the foreseeable future with this overlay, that these are major concerns, major concerns, especially for a town like Ramsey with a volunteer fire department. Thank you. I'm asking these questions to ensure that public health, safety, and welfare, particularly emergency response reliability and emergency access, are fully evaluated as part of the public record for this overlay.
Yeah, well, as I said, and as Mr. Whitaker said earlier, that is addressed during the site plan review process, and that's when that issue is
Purpose of the
addressed.
municipal land use law, section 1 of the municipal land use law, talks in terms of the same words you just used, that one of the purposes is to ensure
Right.
those things are adhered to.
Absolutely.
And every planning board and every zoning board is required to abide by that.
Okay, thank you.
You're welcome.
Good evening, Nick Capuano, 50 Highwood Road.
Raise your right hand, please. Do you swear or affirm the testimony about to give you the truth and nothing but the truth?
Yes.
Please proceed.
Thank you very much. I'm going to piggyback on what Stacy had said, but I'm going to talk about the school system. She covered the emergency management. Did anyone look on the strain on the community resources, specifically the schools? And with rising healthcare and whatnot, and taxes going up, hypothetically, with the potential of 450 families moving into a school system, potentially, what would be the strain on the school system? As a high school principal, I do budgets. I do a lot with education in terms of the enrollment, the increased enrollment, increased class sizes, increased teachers, with benefits and salaries and classroom space and parking. We're already having problems with students parking. Now we're going to increase more, and then potentially 300 new students, 350 new students. What's that going to look like? Has anybody contacted the school system and had conversations with the school system? I'm bringing this to light as things to think about.
Yeah, we all understand that, and unfortunately, the case law is extremely clear.
Correct.
That you cannot stop affordable housing and all that we've been discussing in this housing plan because of that factor.
Excellent. And I was going to respond to that. Yeah, no, I was going to exactly dovetail on that. With that said, you see a lot of schools with the rising healthcare Teachers are getting laid off. You see Hackensack, Montclair, all these schools are struggling. Now we're adding to that. Does the school system go back to the taxpayers, or does the school system go back to town council and say, you know what, we have to hire 100 new teachers? I'm just throwing this number arbitrarily out there. Salaries, benefits, I mean, that could easily be over $1 million. Just something to think about.
Look at Hackensack.
50 teachers are being laid off.
At the same time, they approved 4,000 dwelling units.
Absolutely.
To address their obligation.
Look at the
And that's
surrounding-
why I said earlier, talk to your state legislatures. It's not the council.
Understood.
It's the state legislature that has forced all this upon us.
I hear what you're saying. I think everybody in Ramsey needs to hear this, though.
Yeah.
This is important.
And not just in Ramsey, the whole
Yeah, but
region house too.
People in Ramsey are going to be watching this. So, thank you.
Just to emphasize what Mr. Burgess said, it's happening to all the municipalities. They all have the same concern. Right up the road in Franklin Lakes, you've probably seen it in the paper, 2 corporate campuses have been rezoned for exactly this, 1,400 units for the school system at Indian Hills and Ramapo. And police, library, etc. And Franklin Lakes is a small community. That's a major.
That's the old IBM, correct?
And Beckton Dickinson.
And Beckton Dickinson, yeah.
So it's happening throughout.
Yep.
And again, it's not something the towns want. It's what the towns have been told you've got to do.
Understood. Just, I guess I wanted to see the ripple effect and how it's going to impact the schools. Thank you.
Good evening, Mike Dunn, Town Manager Court.
Swear or affirm the testimony about to give you the truth, nothing but the truth.
I do. Thanks for your presentation and answering all of our questions, Mr. Burgess. I want to make sure I understood something that you said earlier. You mentioned that in negotiations with Fair Share, they wanted overlay zones not only for R5E, but also for the train station at Main Street.
Yes.
I'm wondering, how did the negotiations transpire where we wound up with one versus the other?
They talked about, and I forget how many stories they were talking about, but it was quite a number. And we impressed upon them that the equivalent of a wind tunnel effect on a very narrow street would not be sound planning. And they eventually acknowledged that fact.
So, and the wind tunnel you're referring to would be near Main Street? Is that the idea?
Yeah, Main Street, as you know, is pretty narrow to begin with.
Yes.
But if you had 5-6-story buildings on either side of that street,
mm-hmm.
You know, the image, the character of the area would be dramatically different. And we were able to convince them that, well, one area could accommodate, they were just bad planning to do it there. Oh, on top of it was the issue of parking. You just couldn't get the parking for those residents because the sites are small to begin with. And if you're going to have that grade retail with apartments above, they're not providing any parking.
Mm-hmm. Mm-hmm. I see. My neighbors might think also that their corridors are pretty narrow as well, and could make a very similar argument.
Yeah, I think the distinction that Fair Share was impressed with is what we talked about, how on a 2.5 acre plus parcel, you can get at grade parking. In downtown Main Street, you cannot.
Mm-hmm. I see. Okay, thank you.
My name is Mary Ann Carey. I live at 498 Island Road.
Raise your right hand. You swear or affirm the testimony about to give you the truth and nothing but the truth.
I do.
Thank you.
Okay, I have a document here. I don't know whether you have it. I think it was sent to the secretary. It's called the Ramsey Planning Board Meeting Minutes Analysis. Do you guys have that? Basically, this is a list of all the planning board meetings and what was talked about at them. Do you want a copy of this? I have enough for everybody. Can I approach?
Yeah, go ahead.
I keep one. I can't do Okay, thank you.
Yeah,
Appreciate it.
Thank you.
So, so this lists the council meetings, the dates, and how long they lasted. But my basic question is, and nothing about any of these issues that we've been talking about in the overlay zoning, for all of the ordinances that are about to come forth. It doesn't look like the planning board was ever informed, or it was never talked about in the planning board. So I wonder when the planning board found out about this overlay zone or these ordinances that were coming forth so quickly in our minds. And do you know when?
Well, after the mayor and council did the first reading, it comes to the planning board.
Okay, that's when we found out. So, you know, it was just a small amount of time for.
And remember, as Mr. Burgess said, the litigation and the mediation required confidentiality.
Correct. Yes. You know, I appreciate that explanation. So I understand why. Okay. So you found out just 3 weeks ago too. All right. Well, thank you very much.
Hi, Joe Carey, 498 Island Road. I'm already sworn in. I think just to kind of clarify that, understanding litigation is not discussed in open public meetings. Litigation would be discussed in executive session. We know it happens at the Board of Ed all the time, mayor and council, and you can review their minutes and they say executive session. You don't know what it is because something's going on. It could be a personnel issue, anything that is under litigation. And I guess the question was, how come, because this thing is significantly impacting the plan in Ramsey, how come the planning board in the 16 scheduled meetings between the period of when the housing element was presented, or even after the challenge was filed, there was 5 canceled meetings, and 2 meetings for less than 20 minutes. That wasn't there time there for the board to have an executive session where this could have been brought to the attention, and then it could have been explained, you know, the members of the public members, the class 4 members could have had an opportunity to contribute what they thought. There was no time there. What was?
Is that a question to me?
I'm not 100% sure who I would be asking this question to. Would be to the Mr. Iorio.
Mr. Perry, first, you are on the board, correct? You're on the spirit of time.
And I am not allowed to say anything that happened to me on the board. If anything was,
I'm just stating a fact, right?
Yes, it was.
You're on the board.
Yes.
There was nothing before the board to act on. As you know, the board has agendas based upon applications that come in, ordinance that the mayor and council introduce. The board was not part of any of these discussions regarding the settlement or the mediation. So I'm not sure exactly what you think the board could permanently do on their own when they're not party to any of it.
Well, I think it goes back to my original question to Mr. Whitaker, was what is the role of the planning board in the plan? And and saying the board's role is to review site plans is only talking about half the role of the board. The board is also responsible for the long-term plan and to make sure that everything is in cohesion with the master plan and to design the plan. So, and there wasn't, and I think from everyone's concern was it just wasn't discussed. And now, literally, we stumbled upon this was going on. And we saw this and we stumbled upon an agenda item on the February 11th mayor and council meeting, and it's like, sorry, done deal. And how can that happen? How can members of the board, planning board, who you are public members and you're supposed to be representing the opinions of what public members might see, and decisions made here impact Ramsey for 20, 30, 40, 50 years, as I'm sure Mr. Burgess will agree. And you're being forced to act reactive as opposed to being proactive. And if you're being proactive, we can stand there. Everybody's known this 503 number, 450, 475, whatever it is, that was issued in October 2024. And there are things that we can do that might make the affordable housing people a little bit more happier, so they're not going to come down on us with a sledgehammer. And that's really, I think, is the issue that the board members should really think about a lot. Because here it is, now, I don't know the status of, we've tried to look at the mediation agreements, and we've tried to look at what the varying different things say and what the penalties are. We understand builder's remedy. Not one person has said they're not in favor of affordable housing. Everyone recognizes there is a need. I think from our standpoint, we're standing there and saying, you need 70, but the tactic that we're using is the 20% set aside. So we need 70, and I'm sure we could come up with a dozen different ideas where to find 70 units, or where to build 70 affordable units around the borough and still maintain the character. But the tactic that we're using in this overlay is 20% set aside. So you have 70 affordables. That equals 350 units. And as Mr. Iorio said, I was on the 425 Island when we heard the board, when we heard 425 Island. Those were market rate units. Market rate in Ramsey, 92 Main Street, $1 million. Off of Mechanic Street, $1 million. So we're tearing down 28 homes, well-maintained, small homes. They are affordable. They are what affordable housing is. And look at the characteristics of the community. We're retirees. We're first generation. We're, we have people who don't even know how to speak English, and we're trying to explain to them what's going on. And they're like, what's going on? What's going on? And people have received letters. People are ready. And as Jamie said, people have received letters. People have received letters. There it is. This is very, very real for us. And it is. And as Jamie said, I don't want it. But what about, what about if grandma dies? And then the son who lives in Oregon comes by and says, sell the place. Oh, look at this guy offering more. And that's a real problem for us. And I recognize that the board hands are tied on this, but it's very frustrating for me, the fact that there was no time for you to talk about this. Thank you.
Hi, Stacy Tosney, 41 Ferguson Place. Mr. Verdone, I heard you call him a piece of shit just now, and I am horrified that came out of your mouth. It was either you or him. I looked directly at you, and you said, no, it was him. To do that in this beautiful town, you should be embarrassed.
I have good ears. I do too. Me too. Good. I will. I was unbelievable.
It should be good. I guess I'll make a statement since seem like we're closing up, right? This is obviously falling apart here. Just like the infrastructure with the lights. All right, so it seems like we have a place and zero plan. Alicia, Ferguson Place, Alicia Carbone. 50 Ferguson Place, 46 Ferguson Place, restoring a 1910 half an acre house with my two very young children. So we have a place, we don't have any plan. I'm speaking to the Ramsey people as well as the planning board. It's been said several times that there's no proposed development. We have discussed serious, highly impactful issues that have not been considered. We have discussed some creative ideas that have not been contemplated at all. When do we consider these issues? When do we get creative? Who pays the price for all of this is what you need to answer us and the rest of the town. There's proposed development, there isn't proposed development, but myself and several of my neighbors received this letter within a week of the proposal of the ordinance last month. I'll read you the middle part. We have identified your property 50 Ferguson Place as a prime site for future development. Recent legislative changes in the state of New Jersey have resulted in your property being included in the town's housing element and fair share plan as a potential site to help meet the municipality's affordable housing obligations. This designation significantly enhances the development potential of your site, and we are therefore very interested in discussing a possible acquisition. We'd love to meet with you. So tonight, your decision as the planning board is going to guide us, right? It's going to cause us to reconsider our love for a town that is willing to abandon us, a town that does not value our investments, our families, our children, our safety, our contributions to this town. You'll fight for a parking lot over your people. That's what you represent. Your decision tonight will determine whether you can continue to repeat there is no proposed development. It will no longer be our community.
Okay, so I'll make a statement, or Joe Carey, 498 Island Road. I recognize what's going on here, and I know the pressure is against everyone, and we're very cognizant of March 15th and what the implications of not passing this are. But we urge the board, and when I had asked Mr. Whitaker before, there are 4 different votes here. There is the housing element master plan, and then there are the 3 ordinances. Now, and the different types of vote you have is you're not voting to approve, you're voting to recommend the ordinances. And the governing body has the option to disregard that non-recommendation, or however it might be worded. The planning board, as we tried to find, was not very much involved in what was going on here. And we understand that everyone is pretty much given a fait accompli. But there is one out. The board is charged under the municipal land use law with stewardship of the master plan, not reacting under duress. Major zoning shifts like this, especially overlays placed on stable, established neighborhoods, understanding how it happened. But zoning shifts like this deserve deliberate review, full transparency, thoughtful consideration of other alternatives. And then, even then, if you look at this overlay that we're talking about here, and when you're saying it'll never happen, that means it's realistic opportunity, which is mentioned 14, 15 times in the Affordable Housing Act. Now, 2 other overlays in the neighborhood have had willing sellers, willing buyers, 425 Island Road, and they're still figuring out at Ramsey Lumber. This has unwilling sellers and very aggressive buyers. There's been ample time over the past several months for this board to have been meaningfully engaged in these discussions, even in executive sessions as necessary, understanding this was litigation. Even that could have been discussed. So, we respectfully urge you to send Ordinance 04-2026, the Island Road Overlay Zone, back to the governing body with a recommendation of not, or I guess saying not recommendations, given the reasons, the board was not consulted on this. The ordinance is not compatible with current land use and traffic and circulation goals. They must be repaired. And there are less impactful options to create the 70 units and maybe even additional unmet needs that were not publicly explored or adequately analyzed. If the governing body ultimately believes it must adopt this ordinance and to disregard the planning board's concerns to meet the state deadline, then that decision should rest squarely with the governing body. It should not be said that the planning board endorsed a 60-year-old policy shift without full vetting of alternatives and without the benefit of calm, long-range planning. Again, the borough's on-net meet is 424 units. Using the 20% overlay tool, we're talking 2,120 units that have to be built in Ramsey if this thing is fully built out. And in 10 years, is it 1,000? And then we have to build 5,000 units? So the board should get very much ahead of this. Look at these other alternatives. And sending the message by not recommending it isn't the end of the world. It's just going to the governing body saying, somebody knew what was going on here. No, and they'll say, sorry, we have to do it. And it's not on this board. Thank you.
Anyone else from the public would like to make any statements or have any questions of Mr. Burgess? Okay, not seeing him, we'll close the public hearing. And we will open it up now to discussion by the board. I guess, Mr. Whitaker, could you just...
First discussion would be on the master plan. As I said to you earlier, this amendment, the planning board under the municipal land use law has the jurisdiction to adopt the master plan. It's not something that's sent to the governing body. The ordinances, as I previously stated, those three ordinances and all ordinances, land use oriented, those are reviewed and then a recommendation is made to the mayor and council as to whether they should be adopted or not. If the planning board does not adopt them.
Okay, so I think
the discussion first would be based upon the review this evening is the master plan aspect.
Okay, so we'll open the master plan aspect of tonight's hearing up for discussion by the board. Well, I don't think anyone likes the situation that the board is put in, or that the borough is put in by the state. This is mandated by the state, it's mandated by the legislature. As Mr. Burgess stated, and I agree with him, if we want change, it's really to the state legislatures. For the state to come in and tell a town like Ramsey that you need to create areas for affordable housing in the numbers that they come out with, in my opinion, for a town that's fully developed is unreasonable. With that said, though, the ramifications of not complying with this is very detrimental to the town. If we don't comply with what the state legislature provides, and it's not optional, we can't miss it by a day. It's in the legislature. It says what it says. If you miss it, you lose your immunity. Any developer can come into this town and develop what they want anywhere in this town, including on single family parcels on Island Road. They don't need to get an assemblage. They can get a 1 acre lot and put something in there that is well outside of our zoning, nothing that we would ever approve. And unfortunately, this board would have no ability to stop that. So as a board, we have to weigh the potential for maybe development at some point in the future versus the reality of the facts of that if we don't meet the deadlines and the requirements that the state provides, then the entire borough, including the properties that are in these proposed overlay zones, would be subject to builders' remedies, and developers can do whatever they want. We've seen it before. The lumber yard is a property that developers have looked at. They proposed something that this town was not willing to agree to. It was too tall, it was too dense. I remember one of the arguments was that the fire apparatus couldn't reach the number of floors that they wanted. And eventually that developer backed off. Without zoning in place, a developer like that will come back and probably propose something worse on that site and on other sites in town. So I think the ramifications of not complying with this to the town in general are just too great for the board not to comply with it.
I mean, I agree. The builder's remedy is unfortunately unacceptable. For a lot of good arguments tonight, everyone's had a lot of good points, and unfortunately, like you heard, our hands are tied. It's because we're a state legislature. That's where you got to go. But if you think you're getting aggressive letters now, wait till the 16th. If we don't make this date, those letters are going to come tenfold. It's going to get worse. So as much as this is a tough thing to do, I understand the concerns, this being late, I totally understand. I live next to one of these zones. Realizing the issues, I look at this still the best situation we can do is to pass this and prevent that from doing a builder's remedy. That's the only real feasible option we have left. Now, a lot of people have brought up a lot of good points tonight, whether it's safety, it's development. I urge you to continue doing that. In this town, your state legislature, don't let this be a one and done where this goes and you stop doing this, because everyone's brought up a lot of good points. Within a week, you guys have dissected the information, done a great job, and that's got to continue. So the only way we're going to improve this town is continue to have that level of contribution from you guys and bring things up and not letting this die, whether it's in this town or it's a state legislature. So I feel that's where we have to go. It's a tough decision, but I think this is our responsibility to protect the town from its development and keep builders from coming in doing what they want without any regulation. Unfortunately, that's where I'm going to fall. I think we have to go.
Yeah, I think, what I find ironic about this whole thing is, the state legislature comes up with this legislature that we have to follow. They come up with the Fair Share Housing Authority, and then they know there's these timelines. And they know that when you have these objectors come in, that there's a deadline. And they can stick to their guns and say, this is what we want. And if you don't agree to it, then the ramifications for your town are the builder's remedies. So they kind of put all the towns, not just Ramsey, every town, in a situation where you have to capitulate to some point. I know there's been a lot of talk about, should we have town hall meetings about this and should we discuss this? I think Mr. Burgess, discussed that, and made the point where if you do have these town hall meetings, every potential developer is going to be in that room. And they're going to hear about every site that we're talking about. And they're going to now join into those lawsuits. And Fair Share is basically going to say, okay, on top of what we wanted before, we have 5, 6, 7 developers who all have pointed out properties that they're willing to develop into affordable housing. We want those also included on top of what we already want. So I think, like I said, I think, at some point the legislature has to understand that towns like Ramsey that are fully developed, you can't keep doing this, every so often and having the town go find some more properties that they dictate, you have to comply with. The situation we are in is weighing, the potential development against the builder's remedies. And like Mr. Garbo said earlier, I think the risk to the town for not complying with the deadlines is too great to just let it pass by. Any other comments from any members of the board? Okay, so without hearing any. I guess the first order would be,
The first step, the council, special counsel that Borough of Ramsey had for this litigation, has developed a resolution that the board could consider. And I have already submitted that resolution to you, to look at. And if someone wants to move that resolution, that's your prerogative. But it's part of, the resolution is part of what, special counsel, prepared, who was the counsel for the litigation.
Yes, Mr. Chairman, I do make a motion we adopt the borough's amended fourth round housing element and fair share plan as discussed tonight.
okay, do we have a second?
Second.
Okay. Roll call, please.
Yes. Councilwoman Kuzic?
Yes.
Ms. Daly? Yes. Mr. Gargano?
Yes.
Mr. Palumbo?
Yes.
Mr. Bedoni?
Yes.
Mr. Zavala?
Yes.
Chairman Iorio?
Yes. Okay, so now I think we need to take
You need to take
Each
each
of
of
the
the
ordinance.
resolutions in order.
the ordinances, you mean, right?
The ordinance, the last ordinance would be the one, for the compliance ordinances. The first two specific ordinances you have to go through first.
Okay, so first, we have ordinance 04-2026, which is the new R5E Island Road Multifamily Residential Overlay District. I think we've discussed what this is. I think Mr. Burgess has explained what this zone means. I don't know if anyone has any questions of Mr. Burgess that hasn't already been asked about this specific ordinance. We can ask it now.
The approach you are taking is, does this ordinance, comply with what you've just recently approved in the amended master plan, for the housing element and fair share housing?
Right, so remember, we're not approving the ordinance, we're simply making a recommendation to the mayor and council that the ordinance is in compliance with the fair share element of the master plan that we just approved.
Yes, Mr. Chairman, I do make that motion that we do recommend this to the mayor and council. That is in compliance with the fair share, plan that we just discussed this evening.
Thank you. Can I get a second? Second. Thank you. Roll call, please.
I'm sorry, I didn't get a second. Yes. Councilwoman, Ms. Daly?
Yes.
Mr. Gargano?
Yes.
Mr. Palumbo?
Yes.
Mr. Bedoni?
Yes.
Mr. Zavala?
Yes.
And Chairman Iorio?
Yes. We have our second ordinance, ordinance 05-2026, which is the new R5F North Franklin Turnpike Multifamily Residential Overlay District. Again, this is what, Mr. Burgess discussed before. Does any board members have any further questions of Mr. Burgess on this ordinance? Okay, not hearing any. Does anyone want to make a motion as we did with the prior ordinance?
Yes, Mr. Chairman, I make a motion that we recommend this to the mayor and council, that it is in compliance with the borough's amended fourth round housing element and fair share plan that was approved this evening.
Thank you. Can I get a second, please?
Second.
Roll call, please.
That would be Mr. Gargano?
Yes.
Mr. Palumbo?
Yes.
Mr. Bedoni?
Yes.
Mr. Zavala?
Yes.
Chairman Iorio?
Yes. And we have ordinance 06-2026, which is the affordable housing mandatory set aside. And that is the one where every, what, five units, is it?
Yeah, let me comment on this one. You have a mandatory set-aside ordinance. Under the prior rounds, it required wherever you have 5 or more multifamily units, if they're for sale, it's a 20% set aside. And if they were rental units, it would be a 15% set aside. Under the new fourth round rules, everything is a 20% set aside, whether it's rental or for sale units. That's the one change in this ordinance.
Okay, so this is obviously similar to what we have already in the ordinance, with the one change that Mr. Burgess has explained. Do we have a motion for this ordinance?
Mr. Chairman, I make a motion that we recommend this to the mayor and council, as it is in compliance with the borough's amended fourth round housing element and fair share plans as approved this evening.
Thank you. Can I get a second?
Second.
Roll call, please.
Yes, Ms. Daly? Yes. Mr. Gargano?
Yes.
Mr. Palumbo?
Yes.
Mr. Bedoni?
Yes.
Mr. Zavala?
Yes.
Chairman Iorio?
Yes. Okay, we have one resolution this evening, which is the Rana of Ramsey, DBA Ramsey Acura. Can I get a motion to waive the reading?
So moved. Motion.
And a second?
Second.
All in favor?
Aye.
And can I get a motion to approve the resolution, please?
So moved.
And a second?
Second.
Roll call, please.
Councilwoman Kuzic?
Yes.
Ms. Daly?
Yes.
Mr. Barback?
Yes.
Mr. Palumbo?
Yes.
Mr. Begoni?
Yes.
Mayor Emery?
Yes. We just have on our old business, the Alejandro and Andrea Preza, applications carried to our April 7th meeting.
There's no more 17.
And there's no more 17th? No more 17th minutes. Okay, with that, wait. Oh, I guess we can do that. Sure. Okay, so I guess we need a motion to technically, to nominate, Mr. Garbaz as the, new, vice chair of the board.
This is Councilwoman Cusick, and I want to nominate Ryan Garbaz as vice chairman.
Thank you. Can I get a second, please?
Second.
Roll call, please.
Councilwoman Kuzic?
Yes.
Ms. Daly?
Yes.
Mr. Palumbo?
Yes.
Mr. Begoni?
Yes.
Mr. Zabala?
Yes.
Chairman Igorian?
Yes. With that, I don't think we have any other new business. Can I get a motion to adjourn, please?
Motion to adjourn.
Thank you. Second?
Second.
All in favor?
Aye.
All right, thanks for staying late and sticking with us, everybody.